recess. The House was at the 11th order, and we were debating House Bill 248. Before we start the debate again, I would like to remind the members, or the people in the gallery who are in the audience, that, and I would ask for their indulgence and for their respect and their politeness, and to help us maintain the decorum in the House. That would include no outbursts, no clapping, etc. And this should be an open debate. It should be vigorous, but it also should be respectful. And to that end, I ask you to maintain the decorum in the gallery. Is there further debate on House Bill 248? Gentleman from 6.
Thank you, Mr. Speaker. Before we left for lunch, the good gentleman from 14 kind of reminded us the difference between the Senate and the House. In the Senate, it was pigs and spurs, and here it's mules and twine. But there are a few things that I think we need to point out. First of all, the Affordable Care Act caps the overhead, what's called administrative expense of health plans at 80% for individual policies and 85% for group policies. So what we're talking about here is really the cost of distribution. The cost of distribution. Historically, health plans have paid agents a commission, and that commission varied between 4% and 12%, depending on the product. And that was included in the premium check that customers got, but it was not part. But it was not part of what the premium that was reported to the Department of Insurance, because it really didn't go. It really didn't go to the insurance company. It went to the agents. So when you look at the cost of distribution through the exchange, whether it's a federal exchange or a state exchange, it's likely to be cheaper than the historic commission rate. Now, I have to admit that it's been 9 years since I worked for a health plan, and the commission structure may have changed, but that was the way that agents were paid, and that's the way the product was distributed. The exchange is a new way to distribute product for individual and small group. It doesn't involve large group. It doesn't involve self-funded. It doesn't involve Medicare. It doesn't involve Medicaid. It's only for small groups and for individual policies. And I think that that's important to remember that, because those are the ones that are most sensitive to price differences. Those are the people that are most sensitive to the cost of the policy. And so the difference of 3.5% of premium and 1.7% of premium could make a real difference to the purchasers of insurance in Idaho. That probably is one of the main reasons I think the state-based exchange is better. I also, in my prior life, have had to deal with national carriers and try and correct things for their customers, their enrollees that happen to live and work in Idaho. And let me tell you, the further away you get, the bigger the outfit you're working with. When you work with United, when you work with WellPoint, it doesn't quite work as well as if you talk to Blue Shield of North Dakota, and certainly not as well as when you can handle it internally. So the second reason, local knowledge and ability to respond, I think, is appropriate. And the last thing is, I think that as much as the good gentleman from 14 says it isn't a state exchange, it is a state exchange. We have lots of boards that are not elected. The Workers' Compensation Fund, the health departments in our various areas, the high-risk pool, all of those are appointed positions that, they set a charge for the products that are serviced through those boards. But they respond to what the citizenry and the people of Idaho need. And that's why I think, again, it's a good choice. This model is a good choice for the citizens of Idaho. So, ladies and gentlemen, I think it would be a wise choice, a good choice to vote green on this.
Is there further debate?
Mr. Speaker.
Gentleman from 20.
Would the gentleman from 6 yield for a question?
Would the gentleman yield?
Gentleman yields.
The gentleman yields.
Mr. Speaker, good gentleman, you just told us that the agents used to make a number, I don't remember what it was, 3 to 4%, whatever that was. Do you know what that number would be now?
Gentleman from 6.
Mr. Speaker and good gentlemen, I do not know. I know that the commission structure has changed with the acceleration in healthcare costs and the rapidly increase of premium of 7 to 8% a year. I know many have gone to fixed payment, so many dollars instead of such and such a percent. So I cannot tell you what it is now.
Thank you.
Is there further debate? Gentleman from 13.
Would the gentleman 6 yield to a
Will
question?
the gentleman yield?
Gentleman yields.
Gentleman yields.
Thank you, Mr. Speaker, and good gentleman from District 6. I know this might be hard for you to fathom, but let's say, as a member of the minority party, I know this might be hard for you to fathom, but
Gentlemen, let's be a little respectful.
let's say that you were king for a day, and you could choose one of the 3 options. Would you choose a state exchange, an independent corporate non-body politic exchange, or a federal exchange?
Gentleman from 6.
Mr. Speaker and good gentlemen, I don't see that you've given me 2 choices. State exchange, which may be structured as a body corporate and politic, or it may be structured as a department within Department of Insurance or Health and Welfare or wherever, or a federal exchange. And I would say hands down a state exchange structured either as a body corporate and politic or a department of the state government. Now, one of the problems with it being a department of state government is you have employees, and you have Percy, and you have purchasing, and you have all the other rules of state government that you would have to work under for really what is a tool to help manage private industry, which is private insurance policies.
Follow up?
Will the gentleman yield further?
Gentleman yields.
Thank you, Mr. Speaker.
Gentleman
Good gentleman
yields.
from 6. So if the 2 options are the corporate non-body politic or the state-based government or a state-controlled state agency exchange, what option would you choose?
Gentleman from
The best
6.
Mr. Speaker, if I would pick the body corporate and politic rather than have it run by state employees. However, Mr. Speaker and good gentlemen, that doesn't appear to be the choice we have.
Thank you.
Is there further debate? Gentleman, our good lady from District 11.
Thank you, Mr. Speaker. Would the gentleman from 6 yield?
Will the gentleman from District 6 yield to another question?
Oh, certainly, Mr. Speaker, I yield.
The good gentleman yields.
Thank you, Mr. Speaker, and good gentlemen. So you just were leading into what my concern is, and that is in the bill itself on page 5, line 36. What it does is it references that the exchange and the board will utilize or can utilize the Department of Insurance and Health and Welfare. And so that was my concern, is that now we're going to be utilizing employees of the state, even if they're paid through dedicated funds, they're still going to be under Percy, they're still going to be employees to carry out those 31 named tasks in the work frame. So can you explain how that is different? That's what I'm trying to drill down on, is how this is going to be different, because I think it's still going to be utilizing employees and staff of the state.
Gentleman from 6.
Thank you, Mr. Speaker and good lady. Now, I don't have the 31 tasks in front of me. However, it is my belief that the exchange, as with, say, the the state insurance fund, can go out and seek best bids. And there probably are some tasks that are best done by the Department of Insurance. Cheapest, best way to do it. And I suspect that that's what the board is going to be charged to do, is to run this not-for-profit entity in the most efficient manner possible.
Is there further debate? Gentleman from 22.
Thank you, Mr. Speaker. Would the gentleman from 27 yield to a question, please?
Will the gentleman yield?
Gentleman yields, Mr.
Gentleman
Speaker.
yields.
Thank you, Mr. Speaker. Thank you, gentleman from 27. We worked you out a little bit at the beginning, and hopefully you had a good rest so that we can ask a few more questions. I apologize about that, but I just wanted to make sure that I fully understood the question here at hand. In the Idaho blueprint, it indicates that the exchange will procure navigator services from public or private vendors paid for with exchange grants. But in reading Code of Federal Regulations 155-210F, it indicates that funding for navigator grants may not be from federal funds established by the state to establish that exchange. So I guess my question is, how are we then going to pay for these navigators if we can't use the federal funds for them?
Gentleman from 27.
Thank you, Mr. Speaker. Good gentleman. As I understand it, the first thing that's going to happen is if we have a state-based exchange, the Board of Governors will be appointed, and they will immediately then develop a plan of operation. Now, once the plan of operation is approved, then the state blueprint is going to be amended to however the state, or to conform to the state plan of operation. The state blueprint is, if you will, more of a placeholder. A consulting group, the Levitt Group actually was contracted to help the state develop a state blueprint, basically to cover what needed to be covered so that they could submit that in a timely manner to get that done. But to put the state blueprint into perspective, it's expected that that's going to be amended and amended significantly, and as my understanding is HHS is also expecting that to be amended. With respect to the navigator function, there will be fees coming in immediately. As soon as the key is turned and there's certified health plans that are being put on the exchange, revenue is going to start coming in that is not federal revenue. And the navigators will be paid out of that if they cannot be paid out of the federal funds. So it's not like that there's not going to be any revenue there the first year. There will be significant revenue, but there will be some grant funding to supplement that first year's revenue. Doesn't have to be fully self-sustaining until after the first year, but there should be a significant percent of the state-based exchange that would be self-sufficient during that first year.
Is there further debate?
Can I ask for another question, different subject?
Will the gentleman yield?
Gentleman yields.
The gentleman yields.
Thank you, Speaker. Thank you, good gentleman from 27. I also noticed in our blueprint that it talked about special situations occurring that may occur, and one of them was that if there's lower than expected utilization of the exchange. Another one was if IT or other administrative costs exceeded expectations during startup or during the ongoing phases of the operations. And it specifically asked, do we have a contingency plan to address these issues? And so I was just wondering, do we have a plan in place that will address these issues if there's not enough money?
Gentleman from 27.
Thank you, Mr. Speaker. Good gentleman. That would be one of the first things that I would expect the Board of Governors to immediately address in their plan of operation is what are we going to do about contingency plans with respect to revenues? Because, again, we don't know the price of the products that the insurance companies are going to put on the exchange. We don't know how many people are going to use the exchange, whether it's a federally facilitated exchange or whether it's a state-based exchange. And that, you know, the number of people that use it and the amount that the pricing is for the product on the exchange is going to be used to develop a mechanism to bring revenue in from the exchange. And so I would expect the Board of Governors to address that immediately. And that is why, in my opinion, that's a significantly better model to use to do that, because that's exactly what happens in other, the state insurance fund, et cetera, and the high risk pool, et cetera. Those are the kinds of decisions that board makes on an ongoing basis.
Further debate? Is there further debate? Gentleman from 14.
Thank you, Mr. Speaker. To debate the bill.
Gentleman has the floor.
Thank you. Good members of the body, as we look at this piece of legislation, I think it's important that we go back to where we started and why we're here. And I provided a handout for each of you that I'd like to refer to in my debate, if that's all right. And Mr. Speaker, what I'm referring to is the actual legislation, the Affordable Care Act legislation.
I wonder if a page could bring one of those to the speaker's desk, please. But the gentleman may continue.
Thank you. And this may be a little dangerous to do this after lunch because this may put all of you to sleep, but I'll do my best to keep it somewhat informative. The section I wanted to start with is Section 1321. The title of this section is called State Flexibility. That seems like a good section to start, right, as we discuss this exchange. Let's maybe talk about a little bit about the flexibility that we have as a state. The first section, in general, the Secretary, who is that? That's the Secretary of HHS, shall issue regulations setting standards for meeting the requirements. So what actually is she doing? She's doing one, big A, the establishment and operation of exchange. B, the offering of qualified health plans for such exchanges. C, the establishment of the reinsurance risk adjustment program. And D, any other such requirements. I look at that and I don't see a lot of flexibility there. In fact, the only flexibility I see is how we say yes, ma'am. Next, perhaps under consultation, we have a role to play here. Let's read what that says. In issuing the regulations under paragraph 1, the Secretary shall consult with, who is she talking with? The National Association of Insurance Commissioners and its members, and with the health insurance insurers, consumers organizations, and such other individuals the Secretary selects in manner designed to ensure balanced representation among interested parties. You'd think in the section that talks about state flexibility, maybe consulting with the states would be a good idea. We don't see that at all. Little b, state action. This is where we are at today, folks. This is where we have the opportunity to decide what we are going to build here and if we're going to build it. But so far, all we've learned is that maybe they're going to give us the blueprints on what the store is going to look like. They'll probably tell us what kind of paint has to go on it. They've definitely told us exactly what the products are going to be in the storage. You remember that was subpoint big B. The offering of all qualified plans have to be approved by the Secretary. So far we don't have a whole lot of flexibility. And then we get to the failure. And this is our choices here. And I want to jump to towards the end of that, where it talks about the Secretary and what the default is if this doesn't pass. It says the Secretary shall directly or through agreement with a not-for-profit entity establish and operate such exchange within the state, and the Secretary shall take such actions as necessary to implement such other requirements. This wording here is actually very, very important because the Secretary isn't saying that the federal exchange is a state exchange. If it read like this, the Secretary shall establish and operate such state exchange within the state, that would be an important clarification. It is not there. And in a minute, you're going to see the implications of that. The fact that it's only called out as an exchange. Then going on, you see enforcement authority. Subpoint D is kind of interesting. This seems like they're throwing us a bone here. No interference with state regulatory authority. Nothing in this title shall be construed to preempt any state law that does not prevent the application of the provisions of this title. It seems like a good thing, doesn't it? But unfortunately, it's a red herring. And then subpoint E, little e, has to do with a state that already has exchange. Folks, that is all. Of the hundreds of pages that talk of this law, you have a page and a half that talks about state flexibility. A page and a half. And of that page and a half, you tell me how much flexibility we have there. I don't see that we have much flexibility at all. We have no control of the products in the store, of the design of the exchange. So what do we have? Hundreds of pages of law, and we have a page and a half that mocks us by calling it state flexibility. It gets worse. I told you that unfortunately that red herring existed. Go to now Section 1252, the last line, but it's not preempted under Section 1321D. We don't really have the control that we thought. Now, as you're sitting through this debate, at the top of this paper that I've given you the address, the URL, that you can type into your browser to actually look at the entire bill. And just for fun, you ought to just type in the search words, each state shall. Each state shall. When you're doing that, read all of the requirements that we have. These aren't options. These aren't choices. Each state shall. This is just one example here in Big E, where it says transition planning and oversight. Each state shall submit to the Secretary for the Secretary's approval the income eligibility thresholds. Do we want that? Do we want to be on the hook for that? Do we want to be policing that for our people? I hope not. I did interject one little quote from the letter that we received from the Secretary to our good gentleman on the second floor. This is the only part that is not part of the actual legislation, and I'm hoping it's okay, Speaker, if I referred to this letter.
Without objection.
Thank you. So we're
Gentleman may
talking.
proceed.
Thank you, Mr. Speaker. We're talking about the cost of this legislation. And we've heard a lot about the fact that the federal government is going to be there helping us along the way, paying the bills for us. Well, this was her response back to our good gentleman on the second floor. She said that we must demonstrate legal authority for all necessary state-based exchange functions as described in the Affordable Care Act, including financial sustainability. That doesn't sound like someone who has your back, does it? We have to prove that this is going to be financially stable over a long period of time. So let's talk a little bit about the costs involved in this. Next, Section 1343, risk adjustment. Each state shall assess a charge on health plans and health insurers. The next paragraph, each state shall provide a payment to health plans and health insurance. So we're the middleman here, aren't we? We're having to assess and then pay, and then so what value are we adding other than being the bank for the federal government in this process? I don't see that we're adding any value. And then let's talk about the implementation of this. Look at Section 1413. 1413. It talks about the development of secure interfaces. I know a little bit about interfaces. That's what my company builds, software interfaces. And it says each state shall develop for all applicable state health subsidiary programs a secure electronic interface allowing the exchange of data, etc. And then it goes on to talk about the complexities of these software interfaces that have to be written here. There is the presumption that somehow our state may be able to do this cheaper. I would submit that there may be that logic may not be accurate. You look at this and you think, all right, who has the economies of scale here? Well, one state doing it versus the federal government who is doing it across multiple states. Well, they have economies of scale. So they've now set a price. We don't like the price. We think it's a bad price. But somehow we think on our own we can do it cheaper. We have no economies of scale. Even if we outsource this to another company that thinks they may have built it and can plug and play in our state, they're going to want to be paid for their effort, and as opposed to that being distributed across a number of states where the economies of scale, that we are somehow doing this cheaper. Logic would dictate that we can't do it cheaper. I submit that we may have a situation here where we don't know the price. It's already been stated. We don't know. We don't have all the facts. But we do know what we're going to get charged for it, and that fee may be the best price in town right now because of the economies of scale. Well, the last point I want to make has to do with the real downside of this. Do you remember I made the point about how the fact that this is called they did not put on an equal footing the federal exchange and a state exchange. They could have, in that phrase at the beginning, if it says the Secretary shall set up a state exchange, they would then be on equal footing, but they're not. And as a result, we get to be the bad guys. Section 1401, this is very interesting. Section 1401 has to do with a change in the IRS tax code. If you'll look at that, it refers then below to Section 36B. That 36B is an actual change within the IRS tax code. In other words, the way that this mechanism works is a tax credit. It's a tax credit for those that are on the exchange purchasing insurance. The mechanism is through the IRS tax code. Now, the problem lies in subpoint big A, where it says that these premiums or this tax and the ultimate enforcement has to be is executed is through an exchange established by the state under 1311 of the Patient Protection and Affordable Care Act. That is different than an exchange that the federal government would run in the state. We can't mince words here, folks. This says clearly here, through an exchange established by the state. That's the only place where this mechanism exists. Good members of this body, most everyone came into this chamber today having a pretty good idea of how you're going to vote. The reason I wanted to go through this original legislation is because I felt it gave each one an opportunity for us to check our assumptions and make sure that the law is really in line with what we assume. Because just because we want it to be so, just because we take the word state and put it in front of exchange, we think that it's somehow magically empowering us. Folks, there's no magic here. We are not being empowered to do anything. So I hope this gives an opportunity to check our assumptions, Mr. Speaker, and I hope that we won't sign up to be the puppet. We won't sign up to be the enforcer, because that's the only way this can be enforced, is through that state exchange. I hope that we will all realize that this would be a short-term, tragic mistake. I encourage your no vote.
Is there further debate? Before we get into the next little round, there's been papers that have been distributed to the members without following Rule 72. And so while you're sitting there, you may want to brush up on that, but written material cannot be distributed to the members without the provisions in Rule 72 being followed. Is there further debate? The gentleman from District 3.
Thank you, Mr. Speaker, and ladies and gentlemen of the House. I rise to speak in favor of House Bill 248. And in so doing, I'm going to echo comments that have been made earlier by the good gentleman from District 34. And when he made his comments, he cited the value of local control. So that where we can, where the state of Idaho can, it's much more efficient to be in control of the critical decisions, the key decisions that have to be made. Now, clearly, everybody in this body knows I've never been involved in creating a health insurance exchange previously, so I can't speak from that information. But I can speak from my experience as the mayor of a city, a county commissioner for many years, and in those projects and in those offices, I have built wastewater treatment plants. I have built a solid waste disposal system. I have built a county jail, and in every instance, I had thick manuals of federal regulations in which it said the county shall, the city shall. The word shall was used often. And frankly, we didn't always exactly fit the shall. But we never had an objection from the federal control agents who worked with us in accomplishing those goals, so long as we were headed to achieve the end result, that the wastewater treatment plants functioned, that the outflow into the Spokane River met the purity standards, that the jail would be managed in a way to honor civil rights, etc. And so while I'm aware that the thick manual that we're all confronted with now has many shalls in it, and it seems like in non-negotiable terms, my experience is that a program aimed at accomplishing the concept, the primary concept, is the one that we'll be controlling. So, in echoing then the comments of the good gentleman from District 34, we talked about local control. And just having told you now my experience in working with federal regulations, I want to tell you that for more than a year, it's been my ambition for the creation of a medical insurance exchange that operates independently and without subsidy from any government. I have always believed that the private sector could perform the function of an exchange better and more efficiently than a similar service housed in a state or federal governmental agency. However, today, since that ambition wasn't fully achieved, it's my opinion that House Bill 248 fulfills that ambition to the greatest extent possible and practical. The independent exchange created by this bill will offer voluntary participation by companies, their employees, and individual citizens. There are no mandates for enrollment. Employees of the exchange may not be state employees, and public tax dollars may not be used to sustain its function. The exchange created, therefore, and thereby, will be totally independent and will be self-sustaining. And again, it will provide us with the local control that I think is so essential. Now, just for emphasis, I'm going to repeat portions of the bill that were read earlier. And so just for emphasis, so we all clearly understand, I want to tell you that the exchange is independent. It is not a state agency. If you read the excerpt from page 2 on the establishment of the exchange and the board, under item 2 there it says the exchange created by this chapter is not a state agency, shall not be subject to the purchasing statute and rules of the state of Idaho or subdivisions of the state, and of course it goes on, and you probably all have read that. Item 1 there is where the statement is contained. It says, there is hereby created an independent body, corporate and politic. And such exchange may exercise the authority and powers conferred by this chapter, and such exercise shall be deemed and held to be the performance of an essential public function. And finally, ladies and gentlemen of the House, When it comes time to vote on this bill, I can tell you I will cast my yes vote with immense pride, because I'm certain I will look back upon this day as a day that fulfilled ambitions that I've held for a long time. In those almost 25 years of having to follow federal specifications on building process and building various projects, I've always wanted to make a statement such as made by this bill. So again, Mr. Speaker, I'd like to read from the bill itself. It says, under purpose and intent, page 1, it is the public policy of the state of Idaho to actively resist federal actions that would limit or override state sovereignty under the 10th Amendment of the United States Constitution. Through this legislation, the state of Idaho asserts its sovereignty by refusing to surrender the decision-making authority over health care issues. I will take great pride in voting yes and a refusal to surrender to the federal on this. And so, Mr. Speaker and ladies and gentlemen of the House, I can tell you it is my opinion that House Bill 248 makes a bold, assertive, unambiguous statement of states' rights, and I will be so proud to cast a yes vote on House Bill 248. Thank you for your attention.
Is there further debate? Gentleman from 3.
Mr. Speaker, thank you. I rise to debate against this bill.
Gentleman has the floor.
It would appear that District 3 is about to be disenfranchised. In 2005, the federal government passed the REAL ID Act. Excuse me. It was a significant attempt to usurp both individual freedom and liberty and state sovereignty. In 2008, the Idaho legislature unanimously passed in both houses, and the gentleman on the second floor signed House Bill 606, which can be found in Idaho Code Chapter 3, Title 40, Section 40-322, in which Idaho boldly declared, along with numerous other states, that they would not comply with these unconstitutional mandates. On that day, I was extremely proud of my state government. House Bill 606 was a great bill, and here are a couple of high points. These potential breaches in privacy that could result directly from compliance with the REAL ID Act may violate the right of privacy of thousands of residents of Idaho. Obviously, one of the objections to the REAL ID was the invasion of privacy it created. One of the main functions of the healthcare exchange will be to gather information on American citizens. Data gathered by the healthcare exchange will be centralized in a federal data services hub, which you've already heard about a little bit today. In that hub, a number of federal agencies such as the Internal Revenue Service, the Social Security Administration, the Department of Homeland Security, the Department of Justice, and Health and Human Services will be able to access and share information on every American citizen. Back in 2003, before his election, our current president publicly stated that his goal was a single-payer healthcare system, but we would have to get there incrementally. I would submit that when we end up with a single-payer system of healthcare, the health insurance ID card that will be issued by that organization will amount to the REAL ID on steroids. As technology increases, things like genetic predisposition to diseases and who knows what else we're capable of will be a part of the public record. Privacy, as we've known it in this country, will cease to exist. The REAL ID Act goes on. The mandate to the states through federal legislation that provides no funding for its requirements to issue what is, in effect, a national identification card appears to be an attempt to commandeer the political machinery of the states and to require them to be agents of the federal government in violation with the principles of federalism contained in the 10th Amendment to the Constitution of the United States, and they give some Supreme Court decisions. Apparently, the Idaho legislature of 2008 absolutely believed in the principles of federalism and the 10th Amendment when they unanimously agreed that if we complied with these mandates, we would be allowing the federal government to commandeer the machinery that only a state can provide through its constitutional definition of powers to become agents and assist them in taking away more of our freedoms. In my mind, that is exactly what we're looking at here today. 2 years later, in 2010, our legislature was busy again. They passed the Idaho Health Freedom Act. This is from that act. The statement of public policy, if you will. The power to require a person to regulate a person's choice in the mode of securing health care services or to impose a penalty related thereto is not found in the Constitution of the United States of America, and is therefore a power reserved to the people pursuant to the 9th Amendment and to the several states pursuant to the 10th Amendment. The state of Idaho hereby exercises its sovereign powers to declare the public policy of the state of Idaho regarding the right of all persons residing in the state of Idaho in choosing the mode of securing their health care services. It goes on. It is hereby declared that the public policy of the state of Idaho, consistent with our constitutionally recognized and inalienable rights of liberty, is that every person within the state of Idaho is and shall be free to choose or decline to choose any mode of securing health care services without penalty or threat of penalty. Apparently, okay, let's see. Once again, I was extremely proud of my state legislature. At this time, Mr. Speaker, if I may read from a quote from the gentleman on the second floor.
From what is the
gentleman on the
reading?
second floor? It was his remarks to the Health Care Act of 2010.
Without objection, the gentleman may read.
Thank you, Mr. Speaker, and good body. This was his remarks. Congress and the White House are working out their scheme for pushing through a health care reform bill that has more pages than the U.S. Constitution has words. I guarantee you that not a single member of the House or Senate has a complete understanding of that legislation any more than they understand all the implications of the U.S. Patriot Act back in 2001. What the Idaho Health Freedom Act says is that the citizens of our state won't be subject to another federal mandate or turn over another part of their lives to government control. The 10th Amendment of the Constitution codifies in law that the federal government is one of limited and delegated powers, and that all powers not enumerated in the Constitution are reserved to the states and respectively to the people. I echo those words of the gentleman on the second floor. I would also submit that not one member of our House or Senate can tell us what hoops our state will be forced to jump through if we codify a state insurance exchange, especially since its rules are still being written. I will not be a party to passing it so we can find out what's in it. Also, as great as the bill sounds, I've heard from several hardworking people that are trying to make ends meet, and they were told this year when they did their taxes that since they couldn't afford health insurance, if they do not buy health insurance this year, they will be assessed a $1,300 penalty next year when they pay their taxes. I believe if we go back to the Health Freedom Act, it says, it is hereby declared that the public policy of the state of Idaho, consistent with our constitutionally recognized and inalienable rights of liberty, is that every person within the state of Idaho is and shall be free to choose or decline to choose any mode of securing health care services without penalty or threat of penalty. Mr. Speaker, may I read a short quote from James Madison?
Could gentleman restate your request?
Mr. Speaker, may I read a short quote from James Madison?
Without objection, the gentleman may read a short quote from
Thank you,
James
Mr.
Madison.
Speaker, and good body. In the Virginia Resolution of 1798, James Madison said, "Encroachments springing from a government whose organization cannot be maintained without the cooperation of the states furnish the strongest excitements upon the state legislatures to watchfulness and impose upon them the strongest obligation to preserve unimpaired the line of partition." And I realize those guys wrote differently than we do, and their vocabularies were incredible. It simply stated, he said that without the cooperation of the states and the state legislatures, us, the federal government would not be able to compromise the power of the states. We would have to be willing to give them up. In the mid-1800s, this country took a serious wrong turn. Prior to this time, a study of law in this country meant the study of understanding of God's law. When the founders spoke of the laws of nature and of nature's God, they were referring to the absolute authority of biblical law. Now, a study of law consists of studying past decisions in past cases, or what is commonly referred to as case law. Without an absolute foundation for law, we have now entered into an age of legal positivism. which simply stated is the claim that the state is the ultimate authority for creating, interpreting, and enforcing law. All legal truth is based on the decision of the state. One of the big reasons that America became great was that our laws were uniform, predictable, and applied equally to all, from the greatest to the least of us. Once the door is open for law to change with the whims of society, catastrophe is the inevitable outcome. Two former Supreme Court justices illustrate this ideological divide. Mr. Speaker, if I may quote a couple of Supreme Court justices.
Without objection, the gentleman may read.
Thank you, Mr. Speaker. James Wilson was a signer of the Constitution and a Supreme Court justice. He stated, human law must rest its authority ultimately upon the authority of that law which is divine. Far from being rivals or enemies, religion and law are twin sisters, friends and mutual assistance. To get another perspective, Oliver Wendell Holmes was also a Supreme Court justice. He said this, law is simply an embodiment of the ends and purposes of a society at any given point in its history, beliefs that have triumphed and nothing more. A Supreme Court justice with this worldview can do more to take away our freedom and liberty than a large army. Now our constitutional rights rest largely in the hands of a 5-4 Supreme Court. We saw this in the now infamous Supreme Court decision on the Affordable Care Act. Mr. Speaker, may I quote from the Supreme Court decision on the Affordable Care Act?
Without objection, the gentleman may quote.
We've heard a lot about the majority opinions. Let's take a quick look at the minority opinions, the 4. Whether federal spending legislation crosses the line from enticement to a coercion is difficult sometimes to determine, and courts should not conclude that legislation is unconstitutional on this ground unless the coercive nature of an offer is unmistakably clear. In this case, however, there can be no doubt. They went on to say, the values that should have determined our course today are caution, minimalism, and the understanding that the federal government is one of limited powers. But the court's ruling today undermines those values at every turn. Another quote, imposing a tax through judicial legislation inverts the constitutional scheme and places the power to tax in the branch of government least accountable to its citizenry. And then a quote from the majority opinion. But the court does not express an opinion on the wisdom of the Affordable Care Act. Under the Constitution, that judgment is reserved to the people. District 3 has spoken to me, and their feelings are quite clear on this. Last night, I had dinner with a group, and a couple lobbyists were there. And, as we were eating, one of the guys mentioned that essentially what's happening is our government is going to monetize our debt, what that means is they're going to continue to print money until our money is worthless, hyperinflation. Now, another member at that table suggested that that was not a very great dinner topic, and so we left it. But at that time, my interest had peaked. I'll get back to that. But one thing that cannot be overstated in this debate is the fact that our federal government has no money. We all talk about we're going to get federal money. There is none. There is no such thing. Kootenai County, at our Lincoln Days dinner last week, and both of Idaho's...
Gentlemen, I want to nudge you back on the topic, okay?
Okay. Well,
Gently.
actually, it is on topic.
Gently and with respect.
Okay. But
Please proceed.
Okay. Anyway, our 2 senators spoke, and they painted a very dire fiscal picture. A wise man once told me that if you find yourself digging a hole and burying yourself, the first thing you want to do is stop digging. The simple truth is that America cannot afford the things we are doing now, let alone start a massive new entitlement program. Currently, entitlements use up all the revenue the federal government takes in, and we borrow the money for all the so-called discretionary expenditures like defense and pretty much everything else that would be considered a legitimate role of government. Our senators made it very clear that this current course is not sustainable. Last week, our federal debt surpassed $16.5 trillion. I've heard a number of different illustrations in an attempt to create the picture of just how large this number is, and this is the one that works for me. If you take a stack of $1,000 bills, $1,000 bills, it makes a stack 4 inches high. That's $1 million. That's not very big. How tall would that stack be to make $1 trillion? When I heard this first, I checked the math because it startled me. 63.3 miles. $16.5 trillion creates a stack of $1,000 bills over 1,044 miles high. The federal government has no money. We cannot, we're talking about this like they do, and they're going to come in and save us with money. There is none. There's a verse in the Bible that addresses this. It's Proverbs 22:7. The second half of this verse states, "The borrower is a slave to the lender." Our federal government is borrowing us all into slavery. I ran for this office because I do not believe that my children and grandchildren will experience the same liberty, freedom, and opportunities that I have been so blessed to experience living the American dream. Our founders secured the blessings of liberty for ourselves and our posterity. Please stand with me in doing everything that is possible in our state legislature to preserve the blessings of liberty for ourselves and our posterity. Please vote no to House Bill 248. Thank you.
Is there further debate? The gentleman from District 35.
Thank you, Mr. Chairman. I wish to stand in support of House Bill.
The gentleman has the floor.
Thank you, Mr. Chairman. As I've listened today, my thoughts go back a lot of years, more years than I'd like to admit. I was a hospital administrator at Fremont General Hospital in St. Anthony and the Star Valley Hospital in Afton, Wyoming. And Medicare came on the scene. And there were a lot of comments of the inappropriateness of that legislation at that time. It's still out there, and it's still working, and I don't think any of us would try to pull the plug on the Medicare program for our seniors. I came over here with a strong commitment that local government is the best approach. On many occasions, we've had the opportunity to review issues, and I've always felt that the local government had the best decision-making abilities, whether it be a school board, whether it was county commissioners, or whatever the level was, that the more local we could keep the decision makers, the better the decisions were. And so as we opened this session, there were a lot of questions. Do we want to go with the state exchange or do we want to go with the federal exchange? And I pondered that for about a month. And then there was some representatives that came to me and asked me if I'd like to consider sitting down and reviewing the gentleman on the second floor's bill. And I reluctantly, well, at first I said no. And then the more I looked into it, the more I reviewed what their purpose was and what they were going to do, the more I was interested. And finally, I joined what's been now called the Gang of 16 by various groups, and I'm proud to be a part of that. We went through the process. The governor sent the bill to the Senate, and the Senate debated it for nearly as long as we've been here today, and it passed on a 2-to-1 margin. It came our way. We as freshmen didn't like some of the things in that bill and wanted to strengthen it. And we went through that process and developed what was called the trailer bill. When the bill got to the House, the chairman, speaker, excuse me, and others put that bill together in what's 242 today, with several of those changes that the Gang of 16 had written into it. I think it's a much better bill than it was in the Senate, and I'm proud and honored to be a part of the Gang of 16, and I would urge your vote, your yes vote, when that time comes. Thank you.
Mr. Speaker.
Is there good gentleman from District 33?
Mr. Speaker, distinguished colleagues, ladies and gentlemen of the House, in my younger years, I used to farm with big teams of beautiful Clydesdale horses. And as much as I enjoyed that endeavor, I tried not to plow the same ground twice. So I'll try to avoid mentioning arguments that have already been presented. I must say, however, that it's almost beyond belief to me to think that a conservative state like Idaho is not joining with the 25 states that are resisting the implementation of a state insurance exchange. I pay special tribute today to the state of Texas. That state seems to be leading the states' right movement in this country right now. We've been told during the past several weeks by insurance providers and hospital administrators and people in the various state agencies that it will be easier to deal with Obamacare through a state exchange. No, I agree. In the short term, it will be easier to deal with Obamacare. But in the long run, we'll be selling our birthright for a pot of porridge. That birthright is the sovereignty possessed by the states even before the adoption of the Constitution of the United States and affirmed by that document after its adoption. Ladies and gentlemen of the House, I'd like to contend that if we enter into a state insurance exchange, that will have a chilling effect on national efforts that will be taken up in efforts to modify or alter Obamacare. Most of us sitting in this chambers agree or believe that Obamacare is unconstitutional, despite the 5-4 decision. The fact is, the Supreme Court does make mistakes. It does make mistakes. All we have to do is cite famous cases like the Dred Scott case, or Plessy versus Ferguson, or Roe versus Wade. And it behooves us as states to resist those faulty decisions and seek to change the bad law that is produced by those decisions. Mr. Speaker, may I have permission to quote from President Abraham Lincoln?
Without objection.
This is what President Abraham Lincoln said about an overbearing Supreme Court. If the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by the decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. We've had some success in resisting those unfavorable decisions. In Roe versus Wade, there's an example. We have had some effect in using legal methods to resist these decisions. Unfortunately, a federal judge just recently one single judge nullified some work that we've been doing. It is my view that our efforts to alter Obamacare will be weakened if we act as the handmaidens for its implementation. By setting up a state exchange, we implicitly submit to an unconstitutional system. Ladies and gentlemen, almost everyone in this body on both sides of the debate is concerned about states' rights. We all believe that almost all of us believe that the federal government has overextended its power. It is beginning to micromanage the affairs of state government. Almost all of us believe that. But I will have to honestly say that that expansion of federal power will continue regardless of what we say or do today, unless the hearts of the American people are changed. And those hearts will not be changed without inspired leadership. And that inspired leadership has to come not only from the halls of government, but it has to come from the business community and from the academic community. I dream of a renaissance in our political thought regarding the relationship between the federal government and the national government, a return to the basic principles of the Constitution regarding states' rights, the thinking of men like Jefferson and Madison. I dream of a renaissance, a rebirth. But that will never come without inspired leaders to inspire us regarding the roots, the foundation of this country. And if we don't find those leaders, everything we do and say today will be like sounding brass and tinkling cymbals. Thank you very much, Mr. Speaker and members of the House.
Is there further debate? The lady from District 31.
Thank you, Mr. Speaker. I rise to speak in favor of 248.
Lady has the floor.
Thank you, Mr. Speaker. when I campaigned in the primary, I went to my local friends down the road and talked to them about health care and where they thought health care could be improved in our nation and in our state. One of the concerns that came out during all those conversations, and we talked about Obamacare and what it would do. One of the concerns that I had for my neighbors were jobs, that if a federal exchange, if the federal government was to take over and run health care, jobs would be lost in my community. And that was a real concern for them. I know there are a lot of pieces of this bill that address other things, but in my mind, I have to stand here and listen to my community and listen to what they feel like, how it would affect them. And that was what they told me, was they were more concerned about jobs, and with a state exchange, we would be able to somewhat preserve those jobs and make our local economy better, and that it would not affect their status. There might be some of that happens, but they were concerned about local jobs in their community. The other concern I talked to them about was, everything that I'd heard, and when this came up again and these bills were getting brought forth, I called again and talked to them again, and that was the same thing they told me, was that they were concerned about jobs. And I asked them about a federal exchange, and they even told me there's a federal exchange ready to go. So if you think that it's not going to happen, it will happen, and it will happen right now. I talked to my neighbors this morning on the phone, and their concerns were Obamacare, and I did explain to them how we have no control over that. That's a congressional decision that has to be made. But I have talked to very, very conservative people who have said that a state exchange would be the best way to go. Thank you.
Is there further debate? The gentleman from District 21.
Thank you, good speaker. Would the gentleman from 27 yield to a question?
Will the gentleman yield?
Gentleman yields, Mr. Speaker.
Gentleman yields.
Thank you, Speaker, and good gentleman from 27. Given that a handful of lawsuits are pending against the Affordable Care Act, what would happen if the courts were to strike down some of those provisions, specifically in regards to the Oklahoma lawsuit, the complaint that challenges the IRS rulings that would attempt to enforce tax penalties in a federal insurance exchange?
Gentleman from 27.
Mr. Speaker, I'm going to defer, with his permission, if the gentleman will yield, to the gentleman from District 2 who authored the amendment to the Senate Bill 10, to the previous legislation, to discuss that. He is eminently qualified to do that. Also, I handed out a handout with respect to the description by Mr. Rovner on the status of the Oklahoma lawsuit. So, Mr. Speaker, will the good gentleman from District 2 yield?
Will the gentleman from District 2 yield to that question?
The gentleman from District 2 will yield if the good gentleman would repeat the question.
Will the gentleman repeat the question, please?
Thank you, Chairman. Speaker, we know there's a handful of lawsuits that are pending. One specifically concerns the Oklahoma challenge to the IRS's attempt to enforce tax penalties through a federal exchange. So the question would be, what would happen here if that were to be perhaps sustained?
Gentleman from 2.
What will happen, the specific provision you're referring to is in 41605, subparagraph I. And it was specifically
put in the bill and states, in the event that the Patient Protection and Affordable Care Act, Public Law 11-148, or any section thereof or rule enacted thereto, is declared unconstitutional or otherwise invalid by any federal court. Unless such ruling is stayed, the exchange shall immediately cease to enforce those affected provisions of PPACA or the rules. The intent was that it would be much quicker to terminate, much easier to terminate in the event of a successful lawsuit at the state level. It's likely that the federal government would tie that up in the federal courts for years or decades. And that was the intent for putting it in there, and that's the way I believe it will operate.
Is there further debate?
Yes, follow up, please.
Will the gentleman yield to another question?
The gentleman will yield.
The gentleman yields.
Thank you. I am referring to that very paragraph in the bill. And in this case, though, since it refers to tax penalties that might be assessed in a federal insurance exchange, which perhaps now is not in the current law, even if Oklahoma is successful in getting these penalties portions in a federal exchange, am I correct in assuming that nothing would change because we have a state exchange?
Gentleman from 2.
No, you're not correct to assume that. The Supreme Court, if they ever invalidate a law, they invalidate a law that applies in all jurisdictions. It would not apply selectively across the United States. Federal court jurisdiction is throughout the country. So it would not be an instance where we would commit and not be able to avail ourselves of any ruling along that line. But I think more importantly, you've got to look at the use of the term exchange within PPACA, particularly 1311B1. The legislation defines an exchange and uses that term when capitalized to refer to either a state exchange or a federal exchange if a state does not create one. Then the agency gets a high degree of deference in terms of their interpretation and application, and that is essentially the point of law that's being created and raised within the Oklahoma lawsuit. In the event that Oklahoma is successful about that, its meaning and its ruling would apply universally. And of course, we can always change back and forth from one exchange form to the other. So every state in the country would have the benefit in the event that that was successful.
Is there further debate?
Mr. Speaker, to debate against the bill?
Gentleman has the floor.
Thank you. I find that answer extremely uncomfortable. I do wish to debate against the bill. I don't have specific points to add to many of the comments that have been made, but I do want to express, my concerns. Whenever I discuss this with someone who is intent on voting for the state exchange, they always sort of hold their nose and say, we don't want the exchange any more than you do. But it's the law, we have to do it, at least it'll be under state control. But when I look at the bill, I find very little that looks like state control. Even the control we could have claimed, we've turned over to a nonprofit with very little oversight. So we gain so little with the state exchange, and for so little, I refuse to be complicit to the biggest government takeover in our lifetime. I refuse to be the one that allows any exchange, really, and all the evils it brings. I won't vote for mandates, penalties, subsidies. I won't vote for abortion drugs, health rationing, or new entitlements. Which do you want to hear when all is said and done? Brought to you by Obama or brought to you by the Idaho legislature? Maybe we can't stop the exchange. Maybe we can. But we will certainly not be party to this abuse. And I urge you to vote no on this bill.
Is there further debate? Gentleman from 31.
31A, Mr. Speaker, thank you.
31A.
Yes, I rise to debate the bill and
the
support.
good gentleman has the floor.
Thank you. 248. First of all, it's an honor to be here. And I was calculating the other day that I don't know how wide this building here is, this room, but if it were 140 feet and there's 70 of us in here, then we've all got 2 feet. And if you built these consecutively and tried to put all the people in Idaho in them, you'd have to build a line of these assembly halls about 600 miles. And of course, there's only 2 that have the ability to make laws that affect all the others. So that's the gravity of the situation that we're in and the importance of our decisions here. And I respect all of you. You're people of accomplishment and wisdom, and I value the association. I value your judgment. We all had the honor to attend the Abraham Lincoln Memorial out here last Monday. And that was very tastefully done and rightfully so. A man of great importance to the United States. And of course, he was the one who signed the territorial act that created our state, as has been so eloquently presented. And I can imagine how overjoyed we were at the time to be granted a territory status. And I think back to there again, they had politicians fighting, and that's why the capital left Lewiston and came to Boise. So maybe it's a tradition, I don't know. But I remember that about 20 years later, my forefathers homesteaded in Idaho. They came to eastern Idaho, and they homesteaded in what is now Madison County in about 1883. And our family's been there ever since. But the thing that created this state was a president of the United States, both as a territory, that being Abraham Lincoln, and 7 years after my family came to the state, and that would have been Benjamin Harrison, a one-term president that we don't hear much about. But nevertheless, those were the people that were indebted to our status, and I can only imagine how excited our citizenry was at the time to be granted statehood and to be included in the Union. And so as I come to this body and as a new legislator, that's one of the things that's been a little disconcerting to me, is we've almost wound up in this adversarial role against our nation and our federal government, because we ought to be partnered with them and we ought to be working together to solve some of the ills that have befallen our group. I know that there have been a lot of times of stress, and I'm old enough to remember things, and of course probably the first after Abraham Lincoln and after the Civil War, if you can imagine a vote to be taken as to whether to go to war or not, to cede from your country, how important that would be, and how devastating the results were to everybody. This vote pales in significance a whole lot, but Andrew Johnson then was nearly impeached, and you can imagine the divisiveness and the clamor of that particular deliberation. And then in my lifetime, I can remember the Selma, Alabama, and the problems that we've had with that era, and the Vietnam protests, and the Haight-Ashbury, and the Watts riots, and then later on the potential impeachment of another sitting president, that being William Clinton, and how that came within a vote or so of passing. And so there's been a lot of difficult times. I think this is a difficult time, but to put it in perspective, maybe not of that magnitude. But in spite of all the problems we've gone through as a country, we still are the United States. And I think there's not anybody here that would say anything other than we are the greatest nation that has existed on the face of the earth. So we need to be grateful for that, and remember that association, and remember that unity and why it's important to us. Abraham Lincoln, to quote him again, talked about a nation that cannot long endure if it's divided against himself. And of course, that's a paraphrase of the Bible. The Boy Scouts talk about loyalty and bravery, and Alexander Hamilton in the Federalist Papers, I think number 7, talked about the potential for divisiveness between the states and the U.S. government, the Union as they called it then. You have to ask yourself in those situations, what is our avenue of redress? In other words, if we've been slighted and we've been wrong, then how do we address that? How do we fix it? I've talked to people who say, well, the Supreme Court erred in their judgment. I don't know that we can default to the judgment of that individual to then in turn judge whether the Supreme Court was legal or not.
I mean, our Constitution says they're the top authority in the land in terms of constitutionality, and they have, in fact, ruled on this issue before us. I wonder how far we're going to extend this, because if the states disagree with the nation, are the counties going to disagree with the states? And we've got a bill that's coming up tomorrow in committee that deals with personal property tax. And so if it doesn't get decided in the right way, are the counties going to go ahead and assess personal property taxes as they choose, or are they going to follow the dictates of the state government? How are we going to set this precedent, and where are we going with this thing? The exchange, in spite of all the discussion that we've heard, may actually be a benefit. We really don't know. We haven't had one. But that was the intent of providing an exchange, was to have one, a benefit. But I think that we are still a land of hope, and I think that we're still a state of promise. And that we have, I believe, an exciting and a fulfilling future. This bill does not define us. We define ourselves by the abilities and the vision and the work ethics and the charity that we have and utilize for the benefit of our state and for those who partner with us, the federal government being one of those partners. Our predecessors laid a deep and secure foundation upon which to build this country and this state. We are incredibly blessed, in my view, to be here, but perhaps our most precious blessing is our opportunity and our ability to improve it, to make it better. And of course, that's why we're in session. That's why we have this ongoing process. The value of what's happening here today lies not in the outcome, in my view, but in the process. My son is building a home. And I've had that opportunity twice in my life to have a custom-built home. It's kind of fun to do that. In order to do that, you have to follow a lot of rules. You have to make sure that you're on the property that's zoned correctly. In my particular instance, I was the developer of the subdivision, so I had to go to health and welfare, and they drilled holes and checked the permeability of the soil and drainability of the soil and depth of the water and all kinds of stuff. And so you have to follow those things, and then you have to build the home to code. And so there's a lot of specs. There's a lot of government dictates that tell you how you're going to build this home. But there's a whole lot of latitude, too. And everything that you do in that home is not determined before you start to build the house. You got a floor plan, you know about what you're going to do, but constantly the contractor is coming back and saying, do you want pink, or do you want green, or do you want shag, or do you want whatever? And so there's a lot of that stuff that goes on, and you go as far as you can, and you get all the facts straight that you can, but at some point you got to build a house. Because if you wait for every single detail to be determined, it's going to happen. And I think that's where we're at here, is that we've come a long ways. We have serious disagreements, genuine disagreements. But at some point, you got to build a house. And so I think we go ahead, we pass this bill, we build a house. If there's some rooms that we don't like, or the color of the carpet didn't match the wall, or whatever works out, then fine. Let's come back again next year. We're all assured of a second year at least, because we got a 2-year term. But if we've made some mistakes, let's fix them. But if we don't start now, when do we start? So I'd encourage your positive vote on House Bill 248. Thank you, Mr. Speaker.
Is there further debate? Hearing none.
No.
Freudian slip. Good lady from District 33.
Mr. Speaker, to debate the bill.
The good lady has the floor.
Thank you, Mr. Speaker. You know, in history class, I always wondered, why did history seem to repeat itself? And yet today, I think I'm beginning to understand some of the reasons as to why. You see, our forefathers fought for their freedoms from unfair taxation and for the importance of defending and preserving religious freedoms. The Chief Justices have just said that it is not their job to protect the people from the consequences of their political choices. On June 28th of 2012, the Supreme Court upheld the Patient Protection and Affordable Care Act. The justices ruled that the so-called individual mandate is a tax that Congress can impose on Americans. The justices also stated that the legitimacy of the spending clause depends on whether a state voluntarily and knowingly accepts the terms of these programs. Simply put, the justices are pointing out that while it is not their duty to protect us from the overreaching PPACA law, it is well within the authority of the states to decline handing over the taxing powers through a state exchange. You see, our founding fathers faced a similar taxation battle as we do today. The colonies refused to pay the levies required upon the Townshend Acts. In response, Parliament retracted the taxes with the exception of one, and that was the tax on the tea. In May of 1777, Parliament concocted a clever plan. They gave a struggling East India Company a monopoly on the importation of tea to America. Additionally, Parliament reduced the duty that the colonies would have to pay for the imported tea. See, the Americans would get their tea now for a cheaper price than they ever had been able to before. However, by paying the duty on the tax of the imported tea, they were acknowledging Parliament's right to tax them. Parliament assumed that the colonists would rather pay the tax than deny themselves the pleasure of a cup of tea. Congress, when passing the PPACA laws, thought along the same lines. They passed an imperfect bill, never dreaming that the states would not comply. In Section 1401 of the PPACA law, it authorizes premium assistance tax credits and makes them available only through state-run exchanges. In Section 1311, where the state exchange is set up, taxing authority is given. But the taxing authority is not given in Section 1321, where the federal exchange is set forth. In other words, the states must set up a state exchange in order for the IRS to collect the taxes. States that refuse to create an exchange can block much of Obamacare's spending and protect its citizens and businesses from both the individual mandate, the employer mandate, and 20 other taxes that are within the PPACA law. The text of the law is perfectly clear, and without congressional authorization, the IRS lacks the power to dispense the tax credits or to spend money. Congress deliberately chose to pass a bill with known imperfections. They wanted to use the reconciliation process to make only limited amendments. See, writing a perfect bill would have required too many votes, and it never would have passed. And that is what Congress intended. And there's plausible reasons why Congress would have done this. They wanted the states to create their own exchange. And why is this? Because then the states took on the burden. See, many who support the healthcare exchange have erroneously argued that that it will protect our states' rights. The fact of the matter is that states must abide by literally thousands of pages of federal guidelines and regulations in the Affordable Care Act. And this is all in order to set up a federally, and I repeat, federally accepted state exchange. The states that set up the state exchanges stand to maintain no flexibility, but simply will be complacent in the implementation and administering of this great government overreach into the personal decisions of our businesses and our citizens. This is evident within the blueprint that our state of Idaho submitted to HHS. In Section 1.2, we hand over our powers. And again in House Bill 248, on page 4, lines 40 through 42, we as a state agree to abide by all of these regulations. Because the state has been given the dangling carrot of federal funding in order to set up the state exchange, however, it is very important that we point out this funding is temporary and is subject to the discretion of the Health and Welfare Department, or HHS. See, proponents of the state exchange claim that they can offer consumers a lower cost. However, as we've heard in testimony all day today, we don't know what those costs are going to be. And when we asked to have a fee cap placed within House Bill 248, we were told no, we could not do that. So how do we ensure and protect the consumers of the state of Idaho when we are unwilling to put in writing what we have been saying? PPACA law also puts religions in a position of having to defend and preserve their freedoms and principles. You see, the current law has a very big misunderstanding of what religious liberty is. Under the First Amendment of the Constitution, it states, "Congress shall make no law respecting an establishment of religion or prohibiting the exercise thereof." You see, some religions teach that contraceptive use is unacceptable. However, under PPACA law in Section 1302, essential health benefits require that contraceptive coverage be included. And in Section 1303, there happens to be a fatal flaw. When it comes to our state saying that we've opted out of abortion coverage, in Section 1303, there happens to be a backdoor method for that not to be the case. There happens to be what is called a segregation of funds. And that happens to occur in states that have opted out of federally funding the abortion coverage. It states, in the case of a plan to which subparagraph A applies, the user of the plan shall, out of the amounts not described in subparagraph A, in subparagraph A, it talks about where public funding is prohibited, segregate an amount equal to the accrual amounts determined under subsection C for enrollees for the amounts described. These accrual amounts cannot be less than $1 per enrollee. So simply put, all a qualified plan under a state exchange has to do is state that as additional coverage, they are going to cover an abortion. And then they take and they place these segregated funds, and that means, and they have to give notice. So that those people who are paying premiums within these qualified plans every man, woman, and child will be paying for abortion coverage. See, the Cato Institute advises in blocking the employer tax, state officials would likewise block PPACA's efforts to force religious employers to provide coverage for services they find immoral. Under PPACA, the employer mandate applies only in states that create and fund their own exchanges. People who hold such beliefs should not be required to participate in or fund programs that contradict their fundamental beliefs. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. House Bill 248 offers no protection for these religious rights. You see, the easiest path is not always the right path. Our founding fathers showed extreme courage in standing up to Parliament's authoritarian overreach against all odds in order to defend their freedoms. Their courage should inspire us to defend the freedoms of the citizens of Idaho and say no to the federal government overreach of Obamacare. In the typical case, the Chief Justices look to the states to defend their prerogatives by adopting this simple expedient of not yielding to the federal blandishments when they do not want to embrace the federal policies as their own. We have all said we think this is bad policy. Do we want to accept this as the state of Idaho's policy? The states are separate and independent sovereigns, and sometimes we have to act like it. Idaho acted like an independent sovereign by being one of the first states to sue the federal government over the massive and controversial health care reform bill. The basis of this lawsuit was simple. The state should have the right to reject a mandate from Congress. Every citizen ought to have the power to accept or reject, and Congress has assumed that power, and I think it's wrong. On this point, I must agree with the gentleman on the second floor. It is imperative that we continue this line of thinking and stand by our principles. The state does not have the right to reject a mandate from the federal government. It is imperative that we continue this line of thinking, stand by our principles. The state does have the right to reject a mandate from the federal government. You see, there's one major difference that we face from our forefathers, because unlike the TCOS, there is nothing cheap about this law. There is nothing that will be lower for our citizens. Idaho should not embrace these federal policies as their own. We must stand strong and remember the legitimacy of the spending clause depends on whether or not we as a state knowingly and voluntarily accept the terms of these programs. I, at this time, do not willingly and knowingly accept the terms, and I wish and hope that all of the rest of you can join with me in saying no and standing strong with the 26 states that are saying no as well.
Is there further debate? Good lady from District. I'll allow the gentleman from 23 with your permission. He's been trying to get up for quite some time.
Thank you, Mr. Speaker. I thought I'd ask some questions, but I'm going to bypass that and get right to the debate.
The gentleman has the floor.
Thank you, Mr. Speaker. The issues that I'm going to debate on have not been mentioned here today. I'm going to be talking to you about the proper role of government. I'm going to be talking to you about legal and illegal plunder as taught by Frederick Bastiat in his book, The Law. I'm going to be speaking to you about items that are in the Constitution and those types of things, and I will try to proceed carefully. Mr. Speaker.
And you'll draw each of those back to the House Bill 248, correct?
Pardon me, Mr. Speaker.
And you'll make a connection with House Bill 248 in each of those broad areas.
I sure will.
Thank you.
I sure will. Now, ladies and gentlemen, there's one issue that has not been mentioned today for an option. Yes, we've talked about a federal exchange, and we don't want the federal exchange. We feel like the state exchange is going to be a better option. But there's one other option, ladies and gentlemen, and that is not to have either. And that is a possibility. And I'll explain to you why that is still a possibility. We're going to have an election in 2 years, aren't we? Well, do you think the Fed's really going to get the job done if they have to set up the exchange by then? I hardly think so. We have 25 states out there already that have said no thank you. Do you think they're going to be able to go into those states, and if we say no thank you, do the same thing here within the limits of time? I don't believe so, ladies and gentlemen. If they just don't have the money to do it, and they don't have the manpower to do it, and all we've been asked to do is do it so they wouldn't have to do it. Now, the next point is this. For the last 2 years, we've had a United States Senator come and talk to us. And what was his final words when he spoke to us? He said, we've got to quit compromising and moving more and more to liberalism and the left. We need to start compromising. They need to start compromising and coming back with us. This bill is a compromise in the wrong direction, because this bill will put in one of the last nails into the coffin. Now, I will prove my point, and as the gentleman from 27 mentioned, he mentioned 120 years ago. I won't go back that far, but I will go back a little ways. In 1913, we had a change in the Constitution called the 16th Amendment. And let me read to you out of the Constitution that part that it changed. Article 1, Section 8, the first phrase. Congress shall have the power to lay and collect taxes, duties, imposts, excises, to pay debts, and provide for the common defense and general welfare. That's that term general welfare again. It's also in the Declaration of Independence. And we'll talk about that in a minute. Of the United States, but all duties, imposts, excises shall be uniform throughout the United States. Now let's turn to Amendment number 16. Very short amendment, but it really takes care of some of the parts in Section 8, Phrase 1. Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Ladies and gentlemen, Congress originally only had the power to tax after the census, and they had to apportion it according to the state's populations. Had nothing to do with the amount of wealth that was in that state, had everything to do with the amount of people that lived in that state. And so they'd have the census, apportion the taxes, the state would collect the taxes and move it in. I'm moving there, Mr. Speaker. What happened in 1913 with that opened the door in 1936 for the Supreme Court to do this. In the case of Butler, previous to that time, and let's explain the words of general welfare just a minute. What did that mean to our founding fathers, general welfare? Did that mean that we're going to collect taxes from the whole population and then give everybody back a certain amount? The word general means everybody. No, it did not mean that. They didn't do that. The word general welfare meant to those people this, that through your ingenuity, your thinking power, your reasoning power, and your property called time, you could go out and harvest the resources of the earth and make those into things that would promote you and your family's general welfare to even be better. That's what it meant. It did not mean a redistribution of wealth that we look at today. And how do I know that? the Founding Fathers, and I just passed out a sheet, or had it passed out to you about Davy Crockett. Let's talk to you about that for a minute. Before I do, though, I'd like to explain to you the terms legal plunder and illegal plunder as taught by Frederick Bastiat in the book The Law. Illegal plunder is this. Say it very simply, and that's this. You go to your neighbor and take something and force him to give you something that you couldn't do yourself. And he gives it to you, or you take it. You can't legally do that, can you? That's called stealing. But guess what? We've empowered the government to make it legal to commit plunder. And all we do is say, our agent government, you go out there and collect those taxes and then redistribute those taxes to the have-nots. And I'm coming to that. But that's basically what legal plunder and illegal plunder is. All we did was change an illegal act to make it legal because our agent governments did it. Now let me ask you this question. Who in here believes in the line of authority? I do. In other words, I can't give my government any right to do anything that I can't do myself. And I'll give you a perfect example of that. When a group of people got together, let's say to form a small community somewhere, and there might only been 10 or 15 people, and they hired somebody to go out and do what they have a legal right to do, and that's to defend themselves, their property, and their families. And they hired that individual to go out and do it for them. Did they have a right to do that? Yes, because they have a God-given right to do that themselves. And the moment they hired that gentleman and called him the sheriff, that's the beginning of government. They could not bestow into that sheriff one bit of authority they did not have themselves. Now, if this is a country of the people, by the people, and for the people, you tell me how we can legally give that authority to a government to do things for us that we can't do ourselves. That is a breach of our God-given rights. Now, ladies and gentlemen, we did that very distinctly. And then along comes 1936. And guess what happened in 1936? Basically because we got the 16th Amendment through. In 1936, we had a little case called Butler. And the Supreme Court, without precedent, changed the meaning of general welfare to private welfare. Because now they could tax us directly without census, without apportionment or anything else, and take that money, and by changing the meaning of general welfare to private welfare, all of a sudden they could take from the haves and start giving to the have-nots. Now let me read you something that the Supreme Court said that probably counters that to some degree. And it was done in 1889, and it's on the paper I've passed out to you. One of them says this: why not assume that the framers of the Constitution, the people voted it into existence, meant exactly what it says? And then the one above that one: we are bound to interpret the Constitution in the light of the laws that existed at the time it was adopted. Are they doing that today? Did they do that in the Butler case? Heavenly days, I guess not. The thing that gave them the authority to do is when we changed the Constitution with Amendment 16. Now let's go on down and read that last one. The Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary meaning, as distinguished from their technical meaning. Where the intention is clear, there is no room for construction, no excuse for interpolation or addition. Well, ladies and gentlemen, they've gone quite awry from that, in the Butler decision in particular. Now, what happened after that? Let me give you a little family history, if I may, on that issue. Changing that from illegal plunder to legal plunder, as they did in the Butler case. Guess what I heard when I was a little boy being raised up? Born in 1938, the tail end of the Great Depression. I can tell you this, that was very hurtful to my family. I remember my grandmother saying this one time. They lived in Idaho Falls. There was one crust of bread left in the house. That she had 5 or 4 children at the time. My dad was the youngest. And not a one of those kids were allowed to touch that piece of bread because that was going to be for Uncle Soren when he got home from school because he hadn't had anything to eat. I also remember my dad telling me how many nights they went to sleep at night, and guess what they had for supper? Lumpy Dick. You know what Lumpy Dick is? Boiling water with flour poured in it, and you ate that as it coagulated, and that's what you had for supper. So that depression meant a great deal to my folks. Along comes FDR. And he was their savior. Oh, they thought the sun rose and set in FDR. I even remember when I was a kid that my parents and other people in conversations, and I was just a boy, would listen. And guess what the term that came out once in a while was? A little socialism doesn't hurt.
Good gentlemen, can we get it back to House Bill 248 a little bit?
I'm headed right there, sir.
Yeah, hurry, please.
Okay. The point I'm driving at, folks, is this. The issue we're talking about here is exactly that. We have traveled down the road of socialism, 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 accepting a little more, a little bit more, and a little bit more. And what do we end up with? A floor here today that is discussing the merits of a federal exchange versus a state exchange. Not one word is said about no exchanges at all. Not one word is being said about, ladies and gentlemen, we are a state and we can say no thank you to both if we keep our company with those states that have said no. I don't think we can turn our back on them, ladies and gentlemen. If we do, how much harder is it going to be in the future to say no thank you? This is a defining moment. This is the most important vote I've had to make since I've been in the House, and this is my 11th year. Ladies and gentlemen, I implore you to think about these matters. Is it a proper role of government? And all the things I've talked to you about before then, how can this be a proper role of government when you don't have the authority to give your agent, the government, the right to do this? Where did you get it? You can't assume it. I'm saying to you, you'll be held accountable someday because of that. In closing, let me say this. Thank you, Mr. Speaker, for being patient. I have a whole bunch of grandkids. And my constituents have a whole bunch of grandkids. And Grandpa Nielsen and Representative Nielsen is not going to wake up someday in the future and have any one of them point at me and say, "What did you leave us, Grandpa or Representative Nielsen?" I'm saying, no, thank you.
Is there further debate? Good lady from 30.
Thank you, Mr. Speaker. I rise to declare Rule 38. I am co-owner in a small business in the healthcare industry.
Thank you, good lady. So noted.
Thank you.
Does the lady care to debate?
Yes.
Lady has the floor.
Thank you, Mr. Speaker. I rise to debate in favor of House Bill 248. I want to do and will do everything I can to protect Idahoans from intrusion of the federal government into our daily lives. I believe I will do that today by voting yes and taking a stand to prevent our state from participating in any steps toward a nationalized, single-payer health care system. Those of us who work in the industry know that one already exists. And I refuse to cede even one more square inch of Idaho to them by ceding complete control of this exchange to the federal government, which is what I believe those states are doing, volunteering to be the first partners. Whatever amount of control we have in the state exchange, it will be more than in a federal exchange. I believe there are three important areas where we do retain some control. That is governance, financing, and oversight. In governance, we have the freedom to set the structure. And we are not only limiting the size of state government, but the size of federal government by choosing the independent body corporate and politic. The board will be empowered to adopt bylaws, assess and collect fees, appoint advisory committees, take legal action, contract for services, and develop and implement a plan of operation. This is a big one for me. It will conduct its meetings in public, pursuant to the open meetings of Idaho. I believe Idahoans are entitled to that transparency. Financing. No state tax dollars will be used. The State Exchange Board will be able to determine the costs and, again, ensure a transparent process in doing so. Oversight. This bill will set up the exchange as an entity that must justify its existence by providing value to customers who choose voluntarily to use it. Board members are subject to Senate confirmation. 3 legislators will be on the board as voting members. We will determine who our brokers, navigators, and assisters are based on local decisions. Whatever amount of control we retain with a state exchange, I submit will be more than under a federal exchange, and I would encourage a yes vote on this bill. Thank you.
Is there further debate? Gentleman from 15.
Thank you, Mr. Speaker, to debate the bill.
Gentleman has the floor.
Hope you'll indulge me. I've got a little bit of laryngitis today. Maybe that's to your benefit. I won't speak as long.
You said what we were thinking.
When I was a little tyke, my parents would read me bedtime stories. And some of those stories were about Brer Fox and Brer Rabbit. Now, one of those stories, Brer Fox actually caught Brer Rabbit. You see, Brer Rabbit was out, and he always liked to go hopping down the trail, talking to everybody, talking to Mr. Blue Jay and Mr. Frog and all the folks he met along the way. Well, one day, Brer Fox, he figured out a plan. He found himself a bunch of tar, and he made himself a tar baby out of that tar. Made it into a human-like figure, put some clothes on it, and up hops Brer Rabbit. And in his normal talkative way, he starts talking to the tar baby. He says, "Hey, how you doing today?" And no answer. "Come on, don't you want to talk?" No answer. So Brer Rabbit got a little excited, and he pushed him. Well, that was the first mistake, huh? So Brer Rabbit, he got caught, and then he put his other paw in there and got stuck too. Pretty soon he's kicking with both feet, and he's all tangled up in the tar baby. Well, this is what we've got here. We've got ourselves a tar baby. And the good gentleman from 27, when he was talking about his conversations with the representative from HHS, they didn't know a lot of anything about anything. I sat through 5 sessions on the Governor's Advisory Committee listening to all the information this last summer. One of those occasions we had representatives from the federal government on a phone conference. Same thing. Couldn't answer us any specific questions about cost, about readiness assessments, a lot of different things that they didn't have an answer for. So if they don't have an answer, how do we expect to have an answer to implement this exchange when the rules keep changing? Now, let's talk about rules a little bit. In in the exchange regulations, it says that the federal, and I'll just indicate that in CFR 155.105B1, it says the exchange must be able to carry out the required functions of an exchange. The exchange must be capable of carrying out information reporting requirements. The state must elect to establish an exchange by submitting a blueprint in a form specified by HHS. We finally did that. The HHS kept moving the date, said, oh, you have a little more time, have a little more time. Well, why is that? Because they want us, they need us to do what they don't want to do themselves. They want us to be mixed up with the tar baby. States seeking to operate a state-based exchange or electing to participate in a state-based partnership exchange, state partnership exchange must submit a completed exchange blueprint no later than 30 days prior to the required approval date of January 1, 2013. Well, we did that barely. But another key part of this was that the state must demonstrate operational readiness to execute the exchange blueprint. And the readiness assessment is conducted by HHS. What does that mean? Basically, it means that your exchange is ready to go, ready to operate, readiness assessment. So I asked during the summer this gentleman from HHS, well, so where's the federal government on their own readiness assessment? Well, I can't answer that. I don't know where we're at on that. So the law states that if you haven't submitted your blueprint and you haven't completed your readiness assessment, then you will, and that's by January 1st, 2013, you will have a federal exchange. You lose the state option. So why are we still talking about this? Well, there's a conditional approval that we got, and that gives you a little bit of time. But what does that conditional approval mean? Under the law, the conditional approval, it says, will be granted to those states that do not meet all the exchange approval requirements on January 1st, but are making significant progress and will be operationally ready. I'd like to know what, other than submitting the blueprint, what significant progress we have made. The point is that the federal government keeps changing the rules, and that's exactly what we face with this exchange. We don't know where it will end up in the end. Well, what about this tar baby? I've got the CFRs here, and I'd like to read just a couple of parts of it. Functions of the exchange. Let me go back one here first. Section 155.120, non-interference with federal law and non-discrimination standards. An exchange must not establish rules that conflict with or prevent the application of regulations promulgated by HHS. Pretty straightforward, pretty clear. How much wiggle room does that give us? How much control? 155.200, functions of an exchange. It's interesting what's packed into just a few paragraphs here of what has to be done. Number one, there needs to be oversight and financial integrity. Thank you. The exchange must, that helped. The exchange must perform the minimum functions described in this subpart. And subparts D, E, H, and K. Well, what are D, E, H, and K? D is eligibility determination. Eligibility for what? Eligibility for Medicaid, eligibility for receiving the credit to receive your premium assistance. What's E? E is an enrollment of applicants. That covers all of the information collection, processing. What's H? That's the shop. We haven't even talked about shop. That's the small business exchange that would be part of this. E, there's certification of plans. Of course, that's your qualified health plans, and make sure that they fit the Obamacare model, that all the plans have the mandatory coverages, that they comply with the requirements of the different metallic plans, bronze, silver, gold, platinum, and otherwise comply with the Obamacare mandates. So how much control does that give us? Okay. Let's talk about consumer assistance tools. A call center. Exchange must provide for operation of a toll-free call center that addresses the needs of consumers requesting assistance, meets the requirements outlined. B, internet website. The exchange must maintain an up-to-date internet website that meets all the requirements of paragraph C. Provides standardized comparative information on each available qualified health plan, including at a minimum, premium and cost sharing information. What's cost sharing information? That's all the credits, the premium subsidy that we've talked about. Has to have all that working through this portal. The summary of benefits and coverage is established. Identification of whether the qualified health care program is a bronze, silver, gold, or platinum level. Number 4, the results of the enrollee's satisfaction survey. There's supposed to be a satisfaction survey that's incorporated in all of this as well. Quality ratings assigned, medical loss ratio, transparency of coverage, provider directory, publishing the following financial information, average cost of licensing required by the exchange, regulatory fees required by the exchange, payments required by the exchange, administrative costs of such of the exchange, monies lost to waste, fraud, and abuse. Boy, that's going to be easy to track, isn't it? Provides applicants with information about navigators. We'll talk about that in a minute here. So this isn't just a simple go on the website, plug in where you want to get your airline ticket to. It's going to be processing all of this information, which means we're responsible as a state, as an exchange, that all that is processed correctly. That takes a lot of software, a lot of bugs that are in a system like that. What's next? Well, you need to have an available electronic means calculator to facilitate the comparison of available qualified health plans after the application of any advanced payment of the premium tax credit and cost sharing. So what does that mean? Well, you put in all your health care information, you put in all your income information, and it figures up what your taxes are going to be, see if you get a credit or not, and then it applies it to all of the different plans to see what credit you might get. That's a pretty complicated program. Doing real-time taxes. My accountant can't even do mine at the end of the year because the rules keep changing. To have a real-time tax calculation, that's a challenge. So what happens if they get it wrong? Well, you know what? They'll come and get you. It's a clawback. If it gets figured wrong and you get too much of a premium credit, well, you'll have to pay for it later. And they want us to do that through our state exchange. They want us to do that. Okay, here's another one. Accessibility. The information must be provided to applicants and enrollees in plain language. and in a manner that is accessible and timely. Well, that seems pretty good. But it says here, individuals who are limited English proficient through the provision of language services at no cost to the individual, including oral interpretation, written language, translations, taglines in non-English languages. Well, how many languages do we have here in Boise? We have a lot of refugee groups here in Boise. Of course, there's Spanish. We've got different African dialects. We got Arabic. We got Russian. You name it, we got it. But that's what it says. Doesn't limit it at all. It says individuals who are limited. That's one person. Individuals who are limited English proficient through the provision of language services at no cost to the individual. Who's going to pay for that? We all will. Consumer assistance. Here's another. These are all musts. The exchange must have a consumer assistance function that meets the standards, including the navigator. And we'll get to the navigator here next, except that it says here outreach and education. The exchange must conduct outreach and education activities that meet the standards. Well, what does that mean? In this body, we've had debates here for a number of years about outreach concerning Medicaid. Do we spend money to go out and get people to apply for Medicaid, or we just let them figure it out and do it themselves? We've resisted that type of outreach. But here it is, we're bound to it. Navigators, general requirements. The exchange must establish a navigator program consistent with this section, through which it awards grants to eligible public or private entities. Okay, so now we become a grant administrator. The exchange has to identify who these navigators are and give them grants. Where does the grant money come from? Well, they don't get paid like brokers do through premiums because they're not supposed to have a financial interest. So that's why it's a grant. So this exchange organization is now running a grant program through whatever fees they can assess through the exchange. Speaker would allow, I'd like to read from a couple of news articles about navigators and challenges thus far.
Without objection.
Thank you, Mr. Speaker.
Gentleman may read.
This is from Health Policy Solutions. It says, Health Exchange needs an army of navigators to aid customers. Colorado's Health Insurance Exchange has morphed from a Travelocity-style self-service website to an online interface with in-person navigators slated to help hundreds of thousands of customers choose from an array of complex health plans. The most vexing questions are if there will be enough navigators who will pay them to avoid conflicts of interest. New surveys of potential health exchange clients released Monday found consumers want simple TurboTax-style guidance, help from people in their communities whom they trust, side-by-side comparisons of complex health plans. Thought that's what brokers did. But doubts are surfacing, however, about how exchange managers will be able to create this system by October 1st, how they can avoid having navigators or health insurance brokers steer clients to plans that financially benefit the workers or health systems they represent. Jim Reisberger, Colorado's Commissioner of Insurance, said during an exchange board meeting Monday that building such a large customer service force will be a massive task. Reisberger calculated that in order to enroll the anticipated number of clients, the state will need enough navigators to enroll 800 people per day, 24/7, for at least 6 months. That's a lot of navigators. Where are they going to come from, says Reisberger. That's their insurance director in Colorado. Another article indicates that Arkansas plans to hire about 535 workers. California plans to hire and deploy about 21,000 helpers. Maryland expects a total of 400 staffers. This is from the Health Insurance News. As the state health insurance exchanges are taking shape with only a few months before their release into the marketplace, states are finding it hard to locate enough potential navigators or a guide to the exchange. As many as 30 million residents without health insurance will enroll in exchanges nationwide. Because the products are brand new, numerous, potentially confusing, the government requires each exchange to staff these guides to the plans. So what are we getting ourselves into? We're getting ourselves into a tar baby. Well, what kind of information is going to be collected? Verification processes. Try this one on for size. If an enrollee for whom advance payments of the premium tax are made or who is receiving cost-sharing reduction notifies the exchange that he or she has changed employers, the exchange must transmit the enrollee's name and taxpayer identification number to HHS. You change a job, and Washington knows about it. They collect your Social Security number. They collect your income tax information. They collect your health insurance. All goes into this database. I think it goes to what the good gentleman from 3 was saying, or 5. So what's the rush? One of the good provisions in this bill, or in this law, is that we do have a choice. And the choice is that we can wait and let the federal government see if it can run its program and pull it off. Why should we be the whipping post? Why should we be the enforcer? Why should we take the risk? CFR 155-106 says that a state seeking to approval of its exchange later than January 1, 2013, which means there's no time limit on it. It just says if you want to get approved after January 1, 2013, what do? Well, you do what we've already done, submit a blueprint. Number 2, you have a 12-month period to go through operational readiness. And then finally, you develop a plan jointly with HHS to facilitate the transition. Why are we rushing headlong into this? Once we're in the tar baby, we won't get out. Now, you should have a document on your desk that I handed out. It's flexible exchange options for states. This comes from the blueprint that the federal government requires. And there's a 3-page chart there. It summarizes all of the things that an exchange has to do. If you see under state-based exchange, all of the X's, we're responsible for all that stuff. I even forgot to talk about the consumer stakeholder engagement and support. I think that's a good one to talk about. If you go down this list, it matches up with a lot of things in the CFR here. But let's see here. Stakeholder consultation, 155.130. The exchange must regularly consult on an ongoing basis. What's that mean? Regularly consult on an ongoing basis with the following stakeholders: educated healthcare consumers who are enrolled in qualified health plans. That's consumers, I guess. How do they do that? Maybe through their survey. Individuals and entities with experience in facilitating enrollment, health coverage. Advocates for enrolling hard-to-reach populations, which include individuals with mental health or substance abuse disorders, small business and self-employed individuals, state Medicaid and CHIP agencies. And here's a kicker: federally recognized tribes defined in the federally recognized Indian Tribe List Act. So we're responsible for that too. Public health experts, health care providers, large employers, health insurance issuers, agents and brokers. Exchanges responsible for regularly consulting on an ongoing basis with all of those groups. So anyway, back to the chart. If you look at the front page, there's 3 columns: state-based exchange, state partnership exchange, federally facilitated exchange. We've talked a lot about the 2 polar ends: federally facilitated exchange, which is the default if there's no state-based exchange, and the state-based exchange, which is what we're looking at in House Bill 248. There's not really been much discussion by anybody about state partnership exchange. Well, what is that? It's still a federally operated exchange. But if you look at the column in the middle, it allows the state to do a few things. Under 4.0, plan management, it gives the state the authority over regulating the qualified health plans, which is really what we want. If we want to have control, we want to be able to control the qualified health plans and not have to wait from somebody in Seattle or Washington to approve a plan. But, and then we have to do the related technology to that interface. What we don't have to do, we don't have to do any of the other stuff, all of the tribal consultations, outreach, call center, internet website, navigators, and take the risk of the uncertainty of that. Why hasn't that been discussed? If we had a partnership exchange, and that sounds bad, I know, because I don't think any of us really want to be in partnership with the federal government in this type of thing. But if you can get past the name, there's a couple of things to be cognizant of. Number one, the oversight for the quality health plans would be with the Department of Insurance. That gives us the direct oversight that we want. Second, we wouldn't have faced the risks that are entailed in all of the other parts of the exchange. Wouldn't be responsible for enforcement of tax laws, of gathering information and securing it. And we may say, well, we want that. We want to have control over that. The fact of the matter is, as has been said by a good gentleman from 14 who's here not right now, but there is a certain benefit to economy of scale. During the presentations during the summer, we heard from a couple of partnership states. One of them was Delaware. And they did an interesting analysis, and their analysis was that the least expensive per unit for an applicant would be a state-based exchange because of the economy of scales. Next would be a partnership exchange. It would cost a little more. And finally, the most expensive would be a state-based exchange. Delaware opted to go with a partnership because of the lower cost and the opportunity to have control over those quality health care plans. Another advantage of a partnership exchange, if we're going to have one, if we're going to have an exchange with the state involvement, we're not so deep into it. We can get out if it looks like we really don't want to go down this road. Secondly, it preserves the legal remedies that our small business owners have potentially through the Oklahoma lawsuit, because this is still a federal exchange. If we go down the state-based exchange route, you lose, you give up that argument. I realize that that's been covered somewhat in an amendment to the bill, and that's good. That's a positive thing. But still, this partnership model really wasn't discussed very seriously, and perhaps it should be. Well, I'm just going to close here by saying that nothing in government comes out as simply and as uncomplicated as we think it's going to be. And we know going into this it's complicated. And you think it's going to get any better? I know when I try lawsuits in court and I get a client that comes into me and they give me their story, and I say, oh, that's good. Yeah, sounds like a good case. Well, when I get into it, there's always more to the story, isn't there? And that's the same in life. It's the same with this exchange. We think it's complicated now. We haven't seen the beginning of it. It's a tar baby. Idaho has been in the forefront of resisting federal encroachment, and now we're turning to embrace it. They need us to implement their program, and I'm not inclined, and I'm not going to support it. Thank you.
Is there further debate?
Mr. Speaker.
Gentleman from 2.
I rise to debate in favor of the bill.
The gentleman has the floor.
I commend the gentleman from District 15 to go through in some detail and outline what the duties and the burdens and the elements of a state exchange entail. We've heard a lot of discussion today about the choice that we face in House Bill 248 has been dictated to us. It's been specified with a high degree of detail by the federal government, and we have no choice. We have no discretion. We have no alternative, so we should turn that down. And now we've had a pretty detailed list of all those elements of operation and management and control and decisions and call centers and agents and financing and control and management by an independent board, operational control, and these are elements that allow citizens in Idaho to displace federal control. We're allowed to make those decisions. We and not the feds. It's hard to logically and consistently argue that we have no control and then at the same time enumerate the issues and the items and say, what an overwhelming task. Every one of those burdens we take over, we displace federal control. Every one of those tasks we take over, we do not allow the feds to exercise those burdens, make those decisions. We have those responsibilities. We also are able to make those decisions. The exchange displaces federal control, and I believe that a state exchange also forestalls and keeps us further away from a single-payer system. We get to not only make critical decisions like certification of qualified health plans. The exchange will look at issues like exemptions from the individual mandate, We've talked about issues like call centers, navigators, the interplay and impact of local agents. I urge you to look at the alternatives and make the best choice for the citizens of Idaho. And for those reasons, I'm voting for House Bill 248, and I urge your green light. Thank you.
Is there further debate? Good lady from District 8.
Thank you, Mr. Speaker. Thank you, seatmate, for giving me a little nudge there. Well, ladies and gentlemen, you've had a lot of meat and potatoes today, and you really have. You've had debates that got right to the core of this issue. Of course, I'm going to speak in opposition to the exchange, and the meat and potatoes that you got have been mostly from the opposition debate, but that's my opinion. Anyway, Mr. Speaker, before I go ahead, I want to just briefly assure you this is not going to be very long. I did not get any sleep last night. I am about to go to sleep now, but I have stayed awake because it was important to hear from everybody in this body who wants to be heard. It's back to the wolves because that was brought up earlier and used as a reason to, I guess, support the exchange, and that's just not the case at all. Idaho has wolves because Idaho did not say no. They did not say it no early enough. It was not timely. They probably didn't, I wasn't quite here yet, but I got here a little bit after that. We didn't quite know what was going on. We could be blindsided, et cetera, et cetera. Then we thought we could maybe manage a little bit if we would cooperate with the federal government. And eventually we acquiesced. And even now, although we did finally get to delist, which I think it took us, 20 years, give or take, if we don't maintain a certain level, they go back on the list. So we're just going round in circles, chasing our tail. And I have them right almost in my backyard, so this is a very sensitive subject for me. So if you can't vote no on the exchange, you can put it over there in the field with the wolves, because if you don't say no, you've got another wolf situation. Now, I don't know if I can compete with the tar baby, but I did stay awake most of the night. And I kept thinking, what about tomorrow? I've been through this before. Everybody has to get up and say something, and that's what we are. But the one thing that I thought of lying there in bed was, I am an ex-school teacher, although I didn't make a career of it, was Polonius. I loved Shakespeare. I would not have admitted that as a high school student, but now that I'm a grown-up, I admit that I love Shakespeare, and I kept thinking of Polonius, who was walking down the corridor of the castle, and he ran into the prince, who was reading a book. And Polonius said, "What are you reading, Prince?" And Hamlet answered, "Words, words, words." And so therefore, as lawmakers, that's our stock in trade. Words, words, words. And you've heard just about every word that's ever been put in a dictionary today, except some that I use in slang. But anyway, that's kind of important. Polonius was a little bit of a dithery type of old guy, but he did give his son, Laertes, some good advice. To thine own self be true. And now we get to House Bill 428, which does not stand all by itself in defense of state sovereignty. It is a means to an end. It's the linchpin needed by the federal government to continue with the successful Obamacare, Affordable Care Act program. The federal government needs the state to get this done. The state does not need the federal government. And I realize from what I've heard today, some of us say the federal government will do it, and if they have to do it, they will fail. They will implode on themselves and will be out of the Health Care Act. But anyway, and then I hear, oh, but if we don't do it, then we don't have control. You're not going to have control. But I laid awake a little longer, and then I got to kind of doodling in my head. And, with your indulgence, because I oppose this on principle. You've heard just about everything there is to either, well, mostly to reject it, and then you've heard some reasons why people think it should be accepted. I oppose it on principle for what I just said. It's a means to an end, and it is a necessary linchpin if the federal government ever is able to proceed with the Affordable Care Act. Now, I'm lying there thinking, I don't want to get up, I don't want to go down there, I don't want to go through what we've been going through today. So I'm thinking, and I remembered not the tar baby, but I remembered another instance when I was teaching. It was a story that you've all heard about, the Trojan horse. Remember, the Greeks and the Trojans had been fighting a war for 10 years, much like we do today. And nobody was winning. They had lost their leaders, but there was one crafty old Greek who was skilled in deception, and he came up with a plan. Well, the next thing you know, the Trojans looked out beyond the gate and saw this really wonderfully well-structured wooden horse. They looked around. There were no Greek soldiers. The field was clear. And like too many of us do today, they decided to answer the phone. No, whatever. Anyway, they decided on their own hook, just from what they were seeing and what they wanted to happen, they just decided that, gee, the Greeks have gone home, they've conceded the war, and they've left us a gift to commemorate the wonderful battles we had and what good sportsmen we were. And so they hauled the thing inside the gate. Of course, when they did, then they went and got the only cat they had in town because they wanted to kill it with curiosity. And they looked at the two doors in the belly of the beast. Couldn't wait. More gifts, more stuff, more things, more for everybody. So they opened the doors. Well, you know the rest. The Greek army came out and vanquished the poor ditzy Trojans and sacked the town and eventually won the war. And I've always thought over the years, what would have happened if the Trojans had been a little bit more careful, a little slow to make a judgment, a little less selfish on what they thought might be in there? What would have happened if they'd just left the silly thing outside the gate for, at least 2 weeks, maybe 3, might have been 4. At some point in time, the stench would have been so bad that they would have been alerted that there just wasn't something quite right. But they didn't do that. Instead, we have, over the centuries, the warning, beware of gifts bearing, I knew I'd do that. I did it last night in bed. Beware of Greeks bearing gifts. A word to the wise used to be sufficient. I'm not sure that's the case anymore. Thank you.
Is there further debate? Gentleman from 12.
Thank you, Mr. Speaker. To debate in favor. Thank you. Today, Mr. Speaker, I stand not necessarily in favor of a state exchange, but absolutely opposed to a federal exchange. I'm not here to negotiate on behalf of Idaho. I'm here to protect Idaho. When I talked to people when I was running for this office, this question came up many times. You know, if you were forced to choose between a state exchange and a federal exchange, which would you prefer? And everybody answered the question. Obviously, we feel that we can control these type of situations better on a local level. It wasn't controversial at the time. But there's been a case made for this third option, that somehow we can do nothing and there's no consequence to it. And I am more convinced than ever that that option doesn't exist. Let's make no mistake. A vote against 248 is a vote for a federal exchange in Idaho. A no vote will grant federal government authority to run a federal exchange in Idaho. This debate is about protecting jurisdictional authority in Idaho. If it were as simple as vote no to stop the exchange or Obamacare, we wouldn't even be having this debate. If my good friends that oppose this bill have a plan to stop a federal exchange, please share it. Still to this day, I haven't heard it. We talk about free market alternatives. Great. Let's see them. They don't, by definition, a free market alternative doesn't need our authority. Go ahead and do it. We hear the argument, if we just say no, the feds will stand down. Probably good for a while. What makes you think that that's the case? We have a president that was just reelected. He's got 4 more years to impose this law. There's no reason to believe that that'll be the case. The federal government doesn't back down from something because it's too expensive or it's too hard. People say, why now? It's simple, because before we come back to this House in January of 2014, we will have given the federal government the authority to operate an exchange in Idaho. Whether or not they've gotten to that point, we don't know yet. But we will have given them the authority to, if they do what they say they're going to do. What if the federal exchange isn't ready? Then we don't have to execute the state exchange. By passing 248, we forfeit no rights to continue to fight the Affordable Care Act. We can continue to fight those provisions. Specifically, the mandate. They talk about how it was improperly passed in the federal Congress. We can join those fights. We can still have those debates, and if we win, then we at least control how we get out. Again, if the law is found unconstitutional any time, that ruling will apply to all states equally. The exchange proposed today will not assess or collect tax penalties or assist the IRS. People talk about the 25 other states that are all saying no, like they're all saying no for the same reason. There are many reasons why these 25 states are saying no. They're not all saying it for the same purposes. Some have overpromised in their entitlement programs like Medicaid, and this is an opportunity for them to pass those responsibilities on to the federal government. What I can tell you is that none of those 25 have what Idaho has, and that's the lowest cost health coverage. That has to be protected. We don't protect it by giving away our ability to control the insurance market in Idaho. We've heard a lot of comments today from the opposition that we haven't gone far enough as far as legislative oversight. That's an argument that I may actually agree with. But by giving up the state exchange, we don't benefit that process in the future with a federal exchange. At least with the state exchange, we have the ability as legislators to come back every year and ask those questions of ourselves and see what needs to be changed. One of the major benefits, in my mind, to having a state exchange, again, because it's a protectionary measure, is to control how and when we get out, if we're able to get out. If we are successful in any of these court cases, we pull the ripcord. If we're successful in future elections at a national level, because this is a national law, and the law is overturned, we pull the ripcord. We don't have to go to the federal government and say, pretty please, will you please shut it off? Idaho's not a pretty please kind of state. At least that's my belief. No state tax dollars are going to be spent on this exchange. If we wait, it could cost millions if we decide to go down this road later. We've talked about single payer as an ultimate strategy for the underlying Affordable Care Act. I agree with that. But ask yourself this question. What makes a single payer system more likely? 50 individual states in one federal exchange, or 50 individual state exchanges? I do believe that we all share the same goal, and that's to protect Idahoans from the worst parts of the Affordable Care Act. It just comes down to how. Some members of this body have compared it to David versus Goliath, and in some instances I think that's probably a fair comparison. But the difference is, with the state exchange, the feds already have the ability to create an exchange without anything from us. They don't need our permission. They simply build it and turn it on, and people voluntarily go in, access it, put their information in, and participate. So to use the David versus Goliath analogy, it would be like David going into battle without a slingshot. We have no leverage. We don't even have a weapon to fight that particular battle. That doesn't mean we can't continue to fight the Affordable Care Act. It just means that with regards to an exchange, we don't have leverage on them. The other reason why I believe this is a protectionary measure is that one of the first rules, or one of the first things you learn whenever you're going into a battle or fight, is you have to get your hands up. To me, for the state of Idaho, a state exchange is simply the matter of getting our hands up. You don't do it to win the fight. You do it not to lose the fight. We're not going to block every punch. I'm sure we may not even win the fight. But our alternative is to do nothing, which puts our hands at our waists. We sit there and yell at them extra loud. And where I came from, that's usually how you got knocked out. That's not how you successfully protect and defend yourself. Personally, I'm glad this day has come. This discussion has quite literally sucked the air out of this beautiful building and institution. I look forward to being able to focus on the competitiveness of Idaho for business, education, transportation, anything where our energy actually helps Idaho and Idahoans. And I urge your support.
Gentleman from District 22.
Thank you, Mr. Speaker, and I rise to debate against the bill.
The gentleman has the floor.
Thank you, Mr. Speaker, and good ladies and gentlemen. We've talked a lot today about oversight, and I don't believe we really have oversight. I think it's very lacking in this bill, and I can point out a few things that are really lacking. The board structure, when you appoint the board, they appoint them all for a 4-year term. Normally, when you appoint a board of almost 20 people, you stagger the terms so that everybody doesn't rotate off at the same time or rotate on at the same time. That same board is then allowed to write its own bylaws
And yeah, they can give us a copy of it, but we don't approve the bylaws. For 4 years, you'll have those same people on that board. And then anytime they want to change their bylaws, only has to clear one person, the director of insurance. I don't call that oversight. I call that overview. We'll get a report of what they've changed. But for 4 years, those same 19 people will all be on that board. And then we talk about the fees. We had suggested that maybe in this bill we had put a cap on the fees. No, you can't do that. But they'll report to us their fees, but we have no oversight to it. It's been compared to DEQ. DEQ, we have oversight over their budget, with their rules. We review them. We decide whether we go along with them or not. Their fee structure has to go through both bodies before it gets approved. We don't have that with this. So I think there's, I call it a lot of overview, but not much oversight. And so I think that this bill really lacks in a lot of those areas. I appreciate the effort that the group made to try to improve it. I don't think the improvement is strong enough to make it worthwhile. And then what else I really feel is lacking in this thing is the protection of life and religious freedom. One of the things that I've always held dear all of my life, I've always told people even before when I first ran for this office, is my faith is what guides every decision I make. It's a real faith. I try to live it. I guide all the decisions by that. And we know that with Obamacare, some of the problems they had was with religious institutions and universities that didn't want to implement the rules of Obamacare. And they found a way around it by self-insuring. Well, ladies and gentlemen of this body, I challenge you that any church, any religious institution, that is not the faith. The faith is of the individuals. The faith that we have, that we individually have, no matter what denomination we belong to or what structure we have to, that's a personal faith that we have, and we have no protection under this structure to protect ourselves from those religious freedoms that has been granted to religious institutions by self-insuring. And lastly, ladies and gentlemen, I sat in on the hearing that we had where we asked the public to listen to this bill. I sat in there with our Health and Welfare Committee, and I kept the tabs of those who spoke in favor and those who spoke against. And you may have saw in the paper it was about 2-to-1 in favor or 2-to-1 against compared to those in favor. But I took a different tally. Every person that got up to speak in favor of this bill was a lobbyist for some organization. They were representing some other organization. Every individual that stood up and spoke against this bill was an individual trying to protect their own rights. Granted, there were a couple of lobbyists that spoke against this bill, but the majority, virtually, I say every individual that spoke in our hearing spoke against this bill. And ladies and gentlemen, I will stand with the people rather than with the lobbyists.
So further debate. Good lady from District 35.
Thank you, Mr. Speaker. I'll be standing to debate against the bill.
Lady has the floor.
Thank you. One of the things that this gentleman just previously spoke about that he didn't tell us about the board is that they have indemnified themselves. And if you go to page 5 of the bill, and you're looking on lines 11 through 16, let's see, 11 through 21. It says, the state of Idaho shall not be liable for any obligation of the exchange, and the board shall not be liable for any obligations of the exchange. No member of the board shall be liable, and no cause of action of any nature may arise against them for any act or omission related to the performance of their powers and the duties under this chapter, unless such act or omission constitutes willful or wanton misconduct, and that they may provide for their own legal protection. I have listened to this debate, ladies and gentlemen. It makes my heart sore. I never thought in the years that I've been here I would be here and facing this day. I feel that this is the biggest threat to the sovereignty of this state that I think I've ever had to deal with in my years here. And why I say that is because even in this bill, it says that it is a state exchange and it is not hooked with the federal government exchange. But if you look on page 5 of the bill, and you see that it says, that thereto is, if anything, any section thereof or rule enacted thereof is declared unconstitutional by or otherwise invalid by any federal court, unless such ruling is stayed by the court, which it will be, the exchange shall immediately cease to enforce those affected provisions of the PPACA or rules. So what you're saying here is they have the oversight. They will say, this is a federal exchange. Also, if you go and look on page 6 of the bill, and it talks all of section 2, an emergency existing therefore which emergency is hereby declared to exist, this act shall be in full force and effect on and after its passage and approval, provided, however, that should the Federal Department of Health and Human Services and or the United States Congress change both the establishment date and the eligibility of limitation date for the exchange, the governor shall, upon his determination that such events have occurred, issue a proclamation of declaring Idaho will not be obligated to comply until the new dates are set by HHS or the United States Congress. And so we admit that, in fact, we are under the rules of HHS and what happens there and the decisions they make. Do we have a state exchange? We only have the exchange of enforcement. We will be the enforcement. They cannot do, the federal government cannot do this without conscripting our agencies to do the work for them. They don't have the power to conscript our agencies. We will give them the power with this bill. I feel like we came here, ladies and gentlemen, each of us from our legislative districts, with the obligation and responsibility to protect our people at home. Why would we give up that responsibility to a board that is appointed, that we have no oversight over, that has autonomy, that can set fees, that can make all the decisions of which we have no say? And why would we ever do that? I would say that probably we have been told there are not any options. Well, there are. And several of those have been brought to some of the attention of some of you, which you chose not to look at. I also would tell you that any of the decisions made by this so-called state exchange is given authority to work with our agencies and will work with our agencies, and our employees will be doing the work. Those are fees that are going to be assessed by the board, we will have no oversight over. They also get to decide who qualifies and meets the requirements to even provide medical care in our state. They will decide informed selection and purchase of health benefit plans and who eligible individuals are. The director will administer more money than any person in our state and will be given more power over all the affairs of health care insurance, plus authority over all affairs of the eligible employees and eligible employers than anyone in our state. What other agency have we given the power to decide who can play, or should I say who can pay? Then they say it's voluntary that we can participate. But if we do not participate, then we stand in the way of possible fining by the federal government. Do you think that there will actually be a free market and there will be competition for our health care in our state. I've been here a lot of years. In the years I've been here, those people who have won the state bid for insurance for state employees have been Blue Shield and Blue Cross and no others. In 30 years, those are the only ones who evidently have qualified to provide that insurance. And we have had insurance companies come to us and ask us why they are not allowed to put a bid. And even if they do put a bid, as Delta Dental told us, it's not accepted. This plan admits it's a vehicle run by the federal PPACA when it says those things in this bill, in the two places it says it. And I, like others here, have spent a lifetime, a half a lifetime at least, to protect our republic and our sovereignty of this state, our freedom to choose and our freedom from the tyranny of an over-oppressive federal government gone awry. We do have other alternatives. It makes my heart heavy to watch my own Idaho, my own compatriots hand over their freedom to a growing, broke, and morally corrupt federal government. Not willingly will I do this, and I would plead with you, please don't do this. We have time. We have time. We have another year. You've been told by people here who have been here a while, who have studied this plan forward and backward, and they plead with you to not go forward until we have a good look at what our alternatives might be. I will not go willingly down this path, and I ask you to please give us the opportunity to try again. Thank you.
Is there further debate? Good gentleman from District 26.
Thank you, Mr. Speaker. I rise to debate in favor of the bill.
Gentleman has the floor.
There was a little girl who went to her father and said, "Daddy, do all fairy tales begin with once upon a time?" And he says, "No, honey, some fairy tales begin with if I'm elected." I find myself in a very peculiar position here, Mr. Speaker. I am in favor of this bill because I believe it serves my constituents the best of two absolutely rotten choices. Today, we're having the wrong debate. We're debating the wrong bill. The bill that we should be debating today is nullification. The bill that we could be debating today would be as 8 states have done, bills citing the 10th Amendment, declaring it illegal to have any kind of an exchange, a federal exchange in their states. That is a misdemeanor to assist a federal exchange. A little while ago today in the Oklahoma House, they passed a bill to nullify Obamacare 72-20. And I hear the cries of the lady from 35 and the gentleman from 23. And these are cries in opposition to a federal exchange, crying out against the feds imposing their will over us. That's not the bill that's before us today. Today is a choice between two bad choices. Today is a choice, what is going to best serve our constituents? What is best going to serve the people who live in my legislative district? The debate that I believe most of us want, I believe the vast majority of the members seated in the House want to debate whether or not we should allow the federal government in here in any shape, way, or form. That is the debate. That is the will that I hear. And I think that is where our hearts are. And before anybody tries to use this discussion to preempt the bill that's before us, I would just point out to you, where were you, where was I 2 months ago and 6 weeks ago and a month ago? as we were looking at the various options before us. I would suggest to you that we need to rethink our positions and rethink where we're going. We need to deal with this bill today, and we need to pass this bill today because it is the best of two bad choices for our constituents. But I would encourage you, I would implore you to consider the alternative. We do not have to stop here today. This does not have to be the end of the debate. This does not have to be the end of where Idaho acts with Obamacare.
Is there further debate? Gentleman from 28.
Thank you, Mr. Speaker, and ladies and gentlemen. During the night, I had a lot of things I put together in my mind to tell you today, but I'm going to be brief. To me, this is the defining vote of my legislative experience. This is my 9th year. I have had nothing weigh on me heavier than this debate today and this vote today. And I've thought about this for more than a year. We're talking today about whether or not we are going to have a state exchange or a federal exchange. Ladies and gentlemen, I don't think that is the question. That is what we're arguing about. But that is not the defining question. The defining question is, to me, when you vote, when I vote, when we vote on this piece of legislation and our signature goes on that board, it will be there for the world to see. It will be there for our constituents to see. It will be there for the state of Idaho to see. And it will be this. Did you or did you not vote to implement and enforce the Affordable Care Act upon the citizens of this state? That is the question. We can squabble about the merits of a state exchange versus a federal exchange, and I concede that a state exchange has been put forward to us today is much more appealable. But I will tell you, we know today what the effect of a yes vote will be. We have implemented the Affordable Care Act upon our citizens. What we don't know is the consequence of a no vote. We don't know that. We can conjecture. We can hope. But what we do know is the consequence of a yes. I would ask you, regardless of what you've said, regardless of what you think, regardless of what you've written, today will be the defining decision that you make regarding Affordable Care Act in this state, and how do you want your legacy to read? Do you want it to say that I voted to enforce on the 13th of March, 2013, I voted to enforce and help the federal administration enforce the Affordable Care Act in Idaho? That is the question that is before us. And I implore you, I beg you to go down into the deepest fibers of your being today, down in your heart, and see if that's what you want. See if that's what the legacy is you want to leave as your political experience. I think you understand that I'm against the bill.
Further debate. Gentleman from District 24.
Mr. Speaker, the House, I rise in support of the bill before us. It's interesting, I had some prepared notes, and I will get to some of those, but one of the things was passed out by the good representative from District 23 referenced Colonel David Crockett. It's interesting that that should be handed out today, because one of the very first votes I ever made as an elected official was a no vote on a bill that I stood alone on a much smaller body, and I had not heard of the story, but I was complimented by a citizen, sent this to me, and saying, you stood strong and courageous. So today maybe I've gone full circle, because I see David Crockett's before me again on probably my first difficult vote. in this body. You know, we've been listening to a lot of voices today, ladies and gentlemen, of this great body. There's one common theme. We aren't too trustful of the federal government running Obamacare in our exchange. And many of us hope that the court actions in Oklahoma will rule this as unconstitutional. But we're not here today to discuss the magnitude of the Obamacare or the Affordable Care Act, but here to state and address about the health exchange. The choice we have before us is we can do nothing with a no vote, which is a default to the federally managed Idaho Health Exchange, or expand the state government with an expanded state agency, which has been suggested here today, but I think if it were before us, most of the people suggesting it would be appalled to vote for such an idea. Or establish a state-created independent nonprofit exchange. The bill before us does that by establishing this corporate body politic to manage the exchange. Is it independent? Yes. Does it have oversight? It has more oversight than we'll see with the federal exchange. Could it have more oversight? Maybe, but that's part of the opportunity to have an independent body. I have found myself seeking advice for months, and I've found myself changing my position on this over the past year. And we've been in session here now, I see, 66 days. It was about a month ago when I determined I had to take a stand, make a choice, and that was not very easy. Like many in this body, I had the confidence that one of two events would bring this decision to a close. One was a presidential election that which did not go in the direction I had hoped for, but I did work very hard to influence that outcome. Then I relied on the wisdom of the Supreme Court to rule that the Affordable Care Act was unconstitutional. While some aspects of the Affordable Care Act were declared unconstitutional, many of the provisions and the ones we're dealing with today were upheld by a 5-4 vote. Many were again critical of the decision that was made by the Supreme Court, and some feeling betrayed. Yet many people still rely on parts of the opinion as though they're words of enlightenment. The Court's decision on the Medicaid expansion was one of the small victories in the constitutional challenge, but left much of the ACA as the law of the land, including this health exchange we're debating today. So who should manage that exchange? That is the question before us. So now we're left with a decision. What is in the best interest of the people of Idaho, the economy of Idaho, and accordingly our respective districts? Today, a no will default us, and I think will do great damage to Idaho's economy. We are not here to decide if there will be an exchange. In fact, those in opposition of this bill encourage us to default to a federal exchange. So the fact there will be an exchange is probably one thing we all agree with. While many feel that the Obamacare will collapse under the weight and cost of a federal exchange, I cannot accept that premise. The federal government has grown exponentially without an exchange. To accept the premise that deferring the management of the Idaho exchange will overburden the bureaucracy is unrealistic. There are many examples of big brothers setting up huge bureaucracies that find ways to spend us into oblivion. The federal government can and will fill that void and build the federal exchange one step closer to a single provider. What little control of the benefits and or consumer costs that we can exert, we must. Doing nothing on the assumption that the federal government cannot deliver an exchange is leaving our citizens with a program designed by Washington, managed by Washington, and sending all our fees to Washington. In the past few days, the tone has changed to imply that if one supports a state-managed exchange, you must not be pro-life. This is an unbelievable assertion. In fact, if I can influence the management of the exchange to protect the life of the unborn for one day, or 1 month, or 1 year, or what remains of my life, I choose to trust Idahoans to make those decisions. If some federal law or rule is promulgated that the Idaho exchange will mandate a change that is adverse to my personal values or yours, I would rather have an independent Idaho exchange managed by Idahoans, monitored by the Idaho legislature to stand up to the federal government than have the federal exchange not answerable to the people of Idaho. If Idaho feels the Affordable Care Act has breached our values, I want the full faith and force of the Idaho legislature, The gentleman on the second floor and our Attorney General fighting for us. This bill creates an independent, not-for-profit corporate body politic authorized by the state of Idaho. Thus, it is not an agency of the state, but independent. The federal government will provide funds necessary to establish the exchange, and the ongoing operations must be funded by the fees associated with that exchange. Opponents often state that it will cost the state $10 million per year. The exchange will have cost. However, the independent exchange must establish a business model to operate within the fee structure of the exchange. User fees, not general revenue funding. The fees to use Idaho Independent Exchange should be lower to Idaho than a federal managed exchange at 3.5%. The independent exchange fees are anticipated to be lower, maybe 25 to 50% lower. The new bill assures legislative oversight of this independent exchange. It establishes an implementation timeline that will adjust if the timelines from the federal government are also adjusted. And it insulates Idaho taxpayers from financial risks of the exchange. An independent exchange will have a board of directors appointed by the governor with voting members from the legislature. Mandatory reporting changes in fees or policies will allow the legislature to closely monitor any adverse directions the exchange might consider. There will be a health insurance exchange. I have no doubt about that. I believe an independent exchange for Idaho will provide input on everything from which carriers, agents, and quality of service, imprinting Idaho's conservative values on the benefits, especially in areas that invade one's personal religious beliefs and values. This alternative approach, an independent exchange managed by Idahoans, will insulate us from the financial liability and provide management oversight of an exchange. I will be supporting states' rights, Idaho values, Idaho's economy, pro-life interest, and maximum flexibility with my yes vote on House Bill 248. Thank you.
Is there further debate? Good lady from District 7.
Thank you, Chairman, Speaker.
You're welcome.
I want to debate against the bill.
The lady has the floor.
Okay. I sat here all day and couldn't get up and say anything, but I have to now. Is it really a state exchange if we are accepting federal money for it? How can that be a federal exchange or a state exchange if we are accepting federal money? You can't tell me that it's a state exchange with federal money. Thank you.
Further debate? Gentlemen, good lady from District 28.
Thank you, Mr. Speaker. I rise to debate in favor of House Bill 248.
The lady has the floor.
Thank you. I've heard a lot of things discussed here today, and the thing that rings the truest to my heart is that we are all desperately trying to fight against an onerous law that has been mandated against us and that we've been pressured into trying to find a solution for. It's no easy task, but we have a true responsibility to do what will protect our state. And unfortunately, it sounds like many of us differ in that opinion. I've heard many people say that if we don't do anything, and this seems to be the underlying premise for many of those that haven't read any of the bills, haven't read what's going to happen, what's coming down the pike, is that if we don't do anything and we simply stand with those other 25 or 26 states, that this will fail, it will fall on its face. And I would say to you that I don't see how that can be possible. I work in a medical facility at this current point in time and on a daily basis use a national payer system to handle claims for Medicare and Medicaid. This has been in place for many, many years. I send in my claim information and I receive checks or correspondence stating what needs to be fixed or changed. The federal government has put in place a national payer system before, and there is no reason why they cannot implement a federal exchange. And in fact, there is one that's already designed and only simply needs the pieces that the states themselves would give. People have said, why don't we listen to the 25 states and do what they're doing and stand in opposition? I would say to you, we do stand in opposition to the Affordable Care Act, but I do not see any actions on their part that would push back against this onerous law. And in fact, just the opposite. I'm scared at what is happening because those 25 states have decided to cede their control to a federal government. As as the good gentleman from District 12 mentioned before, will it be easier or harder for President Obama to set up his one-payer system that we seem to all be in opposition against if he has more than half of the states under his federal exchange umbrella and simply needs to pick off those others that seem to already be in his favor? Or if he has Republican states standing in opposition and refusing to cede control to him? We're going to have an exchange. It's a matter of whether we're going to have a state or a federal. And I would assert that if we vote no on House Bill 248, we are simply voting yes for a federal exchange, and I refuse to do that. There was a gentleman in my district that I spoke to recently, in fact, Friday evening. We had a meeting, and I've had many, many emails back and forth with this gentleman. I respect him greatly. He's a constitutionalist, has taught the Constitution in our area for years and knows his stuff and is good at what he does. And we have shared many, many emails on this back and forth about state sovereignty and federalism and doing the right thing. And that Friday evening, as we discussed this again in depth, he finally looked at me and the group that was standing there with us and said, you know, the things that Kelly is saying are accurate. That is what's going to happen. We will have a federal exchange if we don't do a state exchange. That's absolutely true. But I would still vote no on principle. And I looked at him and I said, his name first, but I said, I respect that, and I wish I had the same luxury of simply voting no on principle. But if I do that, you will have a federal exchange. And then what am I going to say to you in 3 months, 6 months, a year from now, when I have completely ceded all of our state control? I've heard others say, slow down. And I ask, how much slower do we need to go? We've been sitting on this for over 4 years now, or for at least 4 years. I say it's time that Idaho takes a stand and we say to the federal government, we don't like what you're doing to us, and we refuse to give you the control over it any further than you've already tried to take on your own. I agree to thine own self be true, and for me, that's a green light on House Bill 248.
Further debate? Gentleman from 13.
Thank you, Mr. Speaker, to debate the bill.
Gentleman has the floor.
Thank you, Mr. Speaker. I don't know in my 7 years here when I've seen a bill that has wore out this distinguished body more than House Bill 248. I have good friends on both sides of this difficult issue, men and women who I respect and admire, but just see the issue from a different perspective. As I've listened to the debate, Mr. Speaker, I've found 2 areas that we agree on. We both hate PPACA, and we both want state sovereignty, and we are fiercely arguing to protect that state sovereignty. The problem is we just disagree on how to get there. One of the ways that I have coped this year with this legislative session, and it's been a true joy for me, is to go home almost every night. I think there's been six times that I've gone to an evening event, but outside of those 6 events, I go home to a beautiful wife and 2 loving little children. Well, last night, Mr. Speaker, I met them at the mall, and we were walking around the mall, and on a frequent basis, my 5-year-old son says to me, "Dad, can we wrestle tonight?" And last night, as we were walking down the halls of the mall, he put his little hand in mine and he said, "Dad, can we wrestle tonight?" I said, "You bet, we can wrestle tonight. I kind of need a stress reliever." He said, "Well, you better bring your A game." The problem is, Mr. Speaker, as I see House Bill 248, it's not our A game. We are going to put into law and give authority to an unelected board to set rates and to set fees. We claim that we have a lot of oversight and we have a lot of leeway if we'll go with a state exchange, but we can't even protect the right to life or the freedom of conscience. We've heard that this independent body corporate politic is like DEQ or the Department of Agriculture, and it's not. That is like comparing apples and oranges. DEQ and Department of Agriculture are a firewall that many times can stop those regulations that come down from EPA because we set their budgets, we review their rules, and ultimately we have the control. One of the things that I've noticed is we've not talked a lot about the details of the bill, and so I'd like to get to the details of the bill. And one concern that I have, Mr. Speaker, is on page 2, lines 35 through 38. It says, Mr. Speaker, may I read from the bill? Thank you, Mr. Speaker. Members are appointed to the board by the governor shall be subject to confirmation by the Senate, provided that, upon appointment, board members shall have full authority to exercise all the rights, duties, and participate in all decisions required by that position. Before they're ever approved by the Senate, Mr. Speaker, they have the ability to exercise all those rights, duties, participate in all the decisions. We had an appointment this year, Mr. Speaker, that was before the Senate that was somewhat contentious. And that nominee went through the process and ultimately was recommended that she would not serve on that commission. The way this particular legislation is set up is that nominee can be appointed by the governor and will have voting rights immediately. And the legislature has no oversight with that. I find that a problem. The other area, Mr. Speaker, that I find the camel's nose under the tent is on page 4, lines 37 through 42. The exchange shall not prohibit a health carrier, stick in your favorite health carrier, whoever that may be, from participating in the exchange or prohibit a health benefit plan or standalone dental plan from being sold in the exchange so long as the health carrier or health benefit plan or standalone dental plan meets all requirement of applicable law and any requirements of the exchange consistent with this chapter. What does applicable law mean? It means anything that relates to PPACA. Any health insurance company that wants to, as long as they meet the requirements of PPACA, they can participate in the exchange. We don't know what that exchange is going to look like, Mr. Speaker, several years from now. There's been a lot of rumors of what will happen in the exchange, what we can expect to see in the exchange. I believe it was a 2,200-page bill when the exchange was passed. Now it's 30,000 pages of rules that have come forward. What if we have something like death panels? We don't have the control over that, because if that health carrier agrees to those death panels, they have to be allowed to participate in our exchange. All applicable law is the loophole in the law that they're going to use to drive anything they want to tie to this exchange. Because as long as it applies to PPACA, anything they can get to agree to PPACA, it's going to be in there. I sat here, Mr. Speaker, and I've heard a lot of people that are frustrated with the federal government. In my 7 years here, I've become extremely frustrated with the federal government. It seems like year after year, all we do is say, you know what, we have to pass this law to conform with the federal government, or we have to pass this law to conform with the federal government. Well, I would remind the body that at one point, segregation was legal in the United States. But one little lady got tired of the federal government telling her what to do. And with your permission, Mr. Speaker, I'd like to read from the biography by Rosa Parks. Thank you, Mr. Speaker.
The gentleman may read.
Rosa Parks was the secretary of the Montgomery chapter of the NAACP. She had recently attended the Highlander Folk School, a Tennessee center for training activist workers on rights and racial equality. She acted as a private citizen because she was tired of giving in. I've reached that point, Mr. Speaker, that I'm tired of giving in to the federal government. Time and time again, we give in to the federal government. And I think maybe it's time that we say to the federal government, we say as a body, we need to have our Rosa Parks moment. We need to push back against the federal government. The good gentleman from District 12 indicated, he would be willing to take a look at other plans. There are other options. The good gentleman from District 15 referenced another option, and possibly that other option is that we go with a partnership exchange. Possibly it's a Rosa Parks option, that we tell our state agencies, as we did in the Idaho Healthcare Freedom Act, we will not spend any money or any time of those employees or any resources of the state helping enact PPACA. Maybe we need to tell the federal government that, you know what, you can try to come in here to our state and set up a federal exchange, but our employees are not going to work with you. You're not going to have that coordination and collaboration with Health and Welfare or Department of Insurance. Maybe that's what the 25 states are trying to say, Mr. Speaker, that are standing up against this, and maybe they're looking to states like Idaho to say, join us in that Rosa Parks moment, where we will stand up to our federal government and say, under no conditions are we going to continue to allow the federal government to be the bully in the room and to push the states around. Mr. Speaker, when I go to battle against the federal government and when we go to battle against the federal government, I want to make sure that we have our A game. I want to be able to go home and tell my son tonight, son, we brought our A game. This bill is not our A game, and I would suggest, Mr. Speaker, that we vote no on this bill and take another run at it. Thank you.
Is there further debate? Good lady from District 28.
I meant to declare a Rule 38 in my debate when I rose, and I forgot to, and I apologize. I'm an office manager for a medical facility in Pocatello, and I do intend to vote.
Duly noted. Then the clerk will make that note in the journal. Good gentleman from District 4.
Thank you, Mr. Speaker. I'd also like to declare a Rule 38. I do work for a company that is involved in the healthcare industry, and this bill may affect.
Duly noted.
Thank you.
Gentleman has the floor.
Thank you. To debate the bill. Mr. Speaker, I'd like to thank the body for the decorum and conversation that we're having today, and thank the Speaker for keeping it civil. And Mr. Speaker, I'd like to say our choice today is between state sovereignty for the state of Idaho and federal control. If we give up control, we will never get it back. In the case of an Idaho-sanctioned exchange, the simple phrasing of saying no is actually surrender. As we've heard today, a vote against 248 is a vote for a federal exchange today. You've been encouraged not to get wrapped around the axle with facts, but the facts are important. Either Idaho creates an exchange or it doesn't. If it doesn't, low-income, lower-middle class, and small business owners that employ such individuals, the exchange-eligible population, will pay dearly for that decision. And what will we gain for their sacrifice if we condemn them? If we load these people with such a burden, will it mean more freedom? Will it mean increased state power? Will it preserve individual rights? No, it will not. Under the Commerce Clause in the Constitution, our federal Congress has stuck us with the unwise law and an accompanying regressive tax under the clear taxing authority in the Constitution. Reprehensible, yes. Unconstitutional, no. Idaho believes in and has always upheld the principles of freedom, limited government, individual rights, and state power over federal power. Allowing the federal government to operate in exchange would be antithetical to all of those principles. Now, I'm extremely happy with the language in our bill, and the attempts at needling the details prove one thing. We have to be proactive. If we choose a federal exchange, we give up power of the details that we're arguing about today. Sovereigns have to choose their own path. They don't follow blindly. Idaho must choose the path that is correct for Idaho. Each of us has a role in protecting our rights, and now is as critical time in that struggle as our country has seen in generations. However, we must do that in accordance with the rule of law, the principle that protects our right to bear arms and freedom of speech, the rule of law. Unfortunately, under the rule of law, federal law has passed both houses of Congress and was signed into law by the President. It was then upheld by the Supreme Court. We must continue our fight at the federal level to overturn this unwise law. At the state level, we need to continue to work within the bounds of the Constitution to ensure our individual liberties. What we cannot do is abandon the rule of law or the fight. We cannot nullify federal law by embracing a federal exchange. I understand the need for symbolic action, but I cannot embrace such a symbol that would hurt our citizens and destroy our hope in creating an Idaho solution to the healthcare crisis. Our fight should never include laying down and surrendering to the federal government on the exchange or any other issue. We must, however, be more proactive in ensuring that we solve our problems, like the healthcare crisis, at home, so the federal government will never garner the power for a law like this one again. Short of scrapping the Constitution of the United States and starting over, the state of Idaho and its legislators do not have the power to overturn this law by defiance. Again, symbolic action is important, but condemning our working class and small businesses to paying the federal government higher taxes and fees is not defiance. The choice we face is to decide what tool will be available for the exchange-eligible population to avoid the federal law's regressive tax. To be clear, if Idaho were to choose federal control instead of the state exchange, it would do nothing to advance freedom and would hurt some of the most vulnerable assets of our economy. If we choose federal control, we hurt no one's pride. We will not disappoint the federal government, and we will not cause the President's plan for America to fail. We'll simply force our citizens to fund it. Idaho must be proactive about protecting its sovereignty. Given two choices with a constitutional yet unwise law, a choice to create a state-sanctioned exchange is the best way to protect Idahoans. Federal law must be dismantled, but if we must do that, we must do so within the bounds of the Constitution. Pretending to have power we don't have will only hurt us more.
Is there further debate? Good gentleman from District 24.
Thank you, Mr. Speaker. Good ladies and gentlemen of the body, I don't intend to talk till 6 or even 4:34.
When do we break the Senate's record? Oh.
Well, I think we're already past that, Mr. Speaker.
Right. Good.
Thank you, Mr. Speaker. I rise in support of the legislation. I'd like to offer a couple of observations concerning some of the history with which I'm familiar. Many of you know these facts, but it is good to repeat them and to go over them again. How was the federal government formed in the United States? It was formed first as an Articles of Confederation by the states following the Revolution, and then after a period of approximately 10 years, those articles were found to be defective in a number of regards, and so a constitutional convention was called, and representatives of the various states at the time sent delegates to the Constitutional Convention. They were representatives of the states that were then in the Union. And one of the great debates that occurred in that constitutional period was the debate over the relative powers of the federal government and that of the individual states, which was creating the federal government. And so this tension over federalism goes back to our founding years. And they found itself in the most extreme situation in the years leading up to the Civil War, when a variety of measures, including nullifications and various measures primarily emanating from the southern states, placed strains on the federal government and on the Union. And ultimately, those strains broke apart, and 4 years of secession and war followed. And 2 years ago in this body, not on the floor, I heard a member privately use the word secession with respect to Idaho's relationship with the federal government. Okay? And I've thought a lot about that word, because I never thought I would ever hear a word like that coming from a duly elected body of an American state, of a union of states, which attempts day by day to make the very best efforts it can for our national and state good. If we go down this road, not towards secession, but towards accepting what the federal government tells us is good for us, we are ceding some responsibility there. I believe that a no vote in this circumstance is a vote essentially to cede that power further. And we've had many expressions here today about how that's inappropriate, how strongly we feel about that secession of power. This will not be the only vote that we will have as legislators, or our successors will have, that will have to deal with the relationship of our state to the federal government. But it seems to me that to cede the power on the front end of this particular legislation to the federal government
Without a willing participation and a pretty well-crafted piece of legislation to involve us in that process would be a mistake. So I'd urge your yes vote on the legislation. Thank you, ladies and gentlemen of the House.
Is there further debate? The gentleman from District 32.
Mr. Speaker, I shan't take long. It's been said, and I think repeated here a little bit, this is paraphrasing an old story that I heard a long time ago, but if all of the members of this body who have drifted off to sleep during this debate were placed end to end, they'd probably be a little more comfortable. We're told today that this is a choice between two bad alternatives. And I display a little thing here on my desk that I'm not going to hold up and violate the rules doing so, but I'm going to just remind us all, Mr. Speaker, that there's no right way to do the wrong thing. And Mr. Speaker, I have to say that I think this is the wrong thing, and there's not a right way to do it. I have asked the question repeatedly since the beginning of this whole discussion. Why does Idaho need an exchange? Period. Not what kind of an exchange do we need, but why do we need an exchange? I have yet to receive an answer to that. And I don't want to hear the answer that says, well, we've got to do this, or the federal government will do that. I'm not interested in that kind of a deal. I just want to know why. Why is that an exchange a good idea for the citizens of this state? Mr. Speaker, I've asked myself some other questions. What does an exchange look like? And how much is this ultimately going to cost our citizens? Now, I'm not talking about the construction of it. I'm talking about the ongoing expenses. Mr. Speaker, I'd just like to quote my father-in-law in that regard, because I think it's apropos. And the answer to the question is, no man knows, and very few women. Mr. Speaker, my dad was a risk taker, as you and I are. And as a result of that, he was never afraid to go borrow money. But it gave him great pause one day when he went to a lender, and the lender stepped out of the room and he read this little sign on his desk. It said, "For which of you intending to build a tower sitteth not down first and counteth the cost, whether he have sufficient to finish it? Lest haply after he hath laid the foundation and is not able to finish it, all that behold it begin to mock him, saying, This man began to build and was not able to finish." My dad told me he almost got up and walked out of the room without asking whether he could borrow money. Mr. Speaker, I really think at this point of the day that we could determine the outcome of this piece of legislation if we just get a chance to vote. I'll be voting no when I get the chance.
Is there further debate? The gentleman from District 22.
Thank you, Mr. Speaker. I rise in debating the bill.
Gentleman has the floor.
Thank you. I would like to first start off by saying, as a freshman, what a wonderful opportunity to sit here with you good ladies and gentlemen. I've not heard any personal attacks on anybody. I've heard concern for our state. That's all. Concern for the state. It's a neat opportunity for me to be involved in this. I would like to discuss a few points of things that I spent a lot of time preparing these notes, so I would like to maybe at least use them, even though it won't change anybody's opinion, I would imagine, and it will delay the process, but I spent a lot of time, so I'm going to go ahead and share some of this information that I ascertained. The
Don't
question we
apologize.
have before here.
You don't need to apologize. We're here till we're done.
The question we have here is House Bill 248. It's been suggested maybe that this is a vote on PPACA. It's been suggested that this is a vote only between a state and a federal exchange. You could even make the argument this is only about House Bill 248, because that's really all it is, 248, nothing else. I reject the idea that if I vote no on this, that I'm voting yes for a federal exchange. This is on House Bill 248. That's all we're talking about right now. And with House Bill 248, I've got some issues, or I've got some concerns about it. One of the things that I find discerning is that this bill does zero to improve the health care in our state. It does nothing to reduce the costs of health care. Everybody knows that this is going to increase the costs. I won't spend much time on the legislative oversight. I think that if we really wanted to have legislative oversight on this state exchange, that we could. I don't think that this is really addressing that issue. I would like to talk about the severability a little bit on this. We've touched on these things as far as lawsuits that are currently sitting out there. There's a handful of them. There's more being added all the time. But one in particular is the Oklahoma lawsuit. We talked a little bit about that. That lawsuit in particular is addressing whether or not the federally mandated penalties on employers and individuals can be assessed in a federal exchange. That's the question. So if the Supreme Court rules that they can't, because that's how the bill is actually written, nothing changes with our state exchange if it is passed. The question before them is if federal exchanges can mandate those penalties. As a state exchange, that would not apply to us. We don't have any get-out-of-jail-free clause there in our bill, in House Bill 248, 41-6105, subsection 2, subsection I, does not address this outcome. It only states that items that are specifically addressed by the Supreme Court then would be null and void. And as a state exchange, that wouldn't apply to us. Let me talk a little bit about flexibility and control. As of March 7th, we know that 26 states have elected not to implement a state exchange. We forget sometimes that seven states have opted for a partnership, which can be classified as a federal exchange. So if you do the numbers on that, that's 33 states that have said no to a state exchange, leaving only 16 that have elected to do a state exchange. I've read a lot of the reasons on why those states rejected a state exchange, and I won't bore you with all the details, but I will summarize some of the points that were made in the letters indicating why they didn't. One governor pointed out that the states do not have flexibility to manage and respond to the unique needs of their citizens, irrespective of who ran the exchange. Another governor indicated that there wasn't any real difference between a federal exchange and a state exchange. He continued to state that a federal government would make all of the important and critical decisions and that the state was nothing more than an administrator. Another went on to say that because states do not have meaningful flexibility under a state exchange, that the states will end up bearing the brunt of any public dissatisfaction with the program, while the federal government, who created this situation in the first place, will be immune from the criticism. I've got a bunch more of summaries of what they said, but I'll just leave it at that. In my research, I can't believe that they were all wrong in their assessments as far as the flexibility and the control associated with that. The other issue I have is the cost. It's been well articulated by those in favor of this bill that we don't know the costs. What we do know is it's going to cost a lot more than what we currently have. Even the Congressional Budget Office estimated that with state exchange, they will see an additional, and that's additional, not just marking up because of the PPACA requirements, but an additional 10 to 13% on the state exchange. It's one more level of bureaucracy. See, the federal government's already created their bureaucracy like everybody has mentioned. Now we're just creating another one. So it's going to require another level there. In the governor's letters that rejected a state exchange, many of them also cited cost as one of the prevailing reasonings. Furthermore, when we talk about cost, I often hear we talk about federal money. We say, well, the startup is going to be federal money, and so that's not ours. It's not us. That's a little disheartening for me to hear that being discussed that way. There is no federal money. There's only your money, my money, and every other citizen's money out there. Any debt that goes into increasing that cost is going to be ours. It's mine, it's yours, it's your grandkids, it's everybody's. I don't like the fact when we say this country has a spending problem, and we complain all the time about how money is spent, but we get a little bit of money thrown towards our direction, and what do we say? Yep, we're good, we'll take it. And I don't like that. Final issue I have with regards to cost is simply that we don't know. We don't know how we're going to pay for our navigators yet. We don't have a contingency plan if the costs exceed what we expected. We don't even have that plan yet. It doesn't exist. We're going to develop one later. So that makes me a little nervous there. And my final reason for voting no on House Bill 248 has to do with being in a hurry. And we talk about the DEQ. I used to work with a lot with the DEQ in my former life. Spent a lot of time working with them, and I understand that organization pretty well. I also work directly with the EPA. The reason being is the state of Idaho does not have primacy over all EPA programs out there. We've picked and we've chosen, and we've taken those aspects as they've come along after we've evaluated them, after we've determined whether or not it's a good program or a bad program, and then we've gone ahead and implemented those. Clean Water Act, Clean Air Act, our Stormwater Protection Plan right now, we don't do. It's just one of those things we haven't gotten around to yet. State of Idaho hasn't taken the initiative to become a state OSHA program yet either. Whether we do that or not, that's up to us. That's great, because those are decisions that take a while to figure out. We made those decisions after we found out what our options were. We saw what it looked like. We studied, we learned, we said, you know what, we think we can do better. I don't think that's a bad approach to be able to do that. That reminds me of when I went hiking once with a bunch of Boy Scouts, and we were up in some wilderness area, and we were traveling along a river, and I'd love to be able to tell you where that was, but I don't know. We go on a lot of those things, and I'm usually just asked to tag along, and I do that. So I get in the car, and I go where they point me, and I show up and put on my backpack, and I go. But we were along the banks of this river, and it was fairly steep, where we got up a little bit higher up into the hill. And it was steep enough that you couldn't really, you didn't want to fall down the edge, because there was the river down there, another 75 feet down below. Up above, we had the bushes so thick that you couldn't move that way. So it was essentially a single file line. We had a dozen Boy Scouts there. And this trail was pretty tight. There's only one way to go, and we were going that way. And as I was walking along, I noticed that there was some bear scat on that road. You looked at it and you thought, huh, it's interesting. And as we continued on down the path, we saw more and more of this, and it was fresher and fresher. And we finally rounded a corner, and there was a bear, a dozen feet or so in front of us. And I think we scared him just as much as he scared us. And I was the only one that was armed at the time, and so I was summoned to the front and asked to stand there. And so I came up to the front, and we stood there. It was a little bit difficult task trying to get around everybody, but I got there, and I promised, Speaker, that I will get to the point here, and I appreciate your indulgence. But as I got there, I stood there, and the bear had gone around the corner, and it was a blind corner we couldn't see. And we stood there for a little bit, and we thought, what should we do? Should we turn around and go the other way? Or should we move forward? We thought about it for a while, and we thought, well, let's just go ahead and move forward a little bit, and we did. And if we didn't chase that bear for another half mile down the creek, you know, it was making me a little nervous, because eventually I thought that bear's going to get tired of me pushing him. He's going to come back and get us. But turned out fine. The Boy Scouts all made it back, much to the chagrin of some of their parents. But my point is that when we saw that problem, we couldn't go backwards. We couldn't go to the left. We couldn't go to the right. We were stuck. And I feel like that's how we are right now. We don't have much options. That's been mentioned by just about everybody, that we kind of in a bad situation here. But I think the wisest thing to do was to wait, give that bear a little bit of chance to get on around the corner so we didn't run onto him again. We don't even know if there's a bear around the corner with this bill. Maybe there's not. Maybe I'm reading a lot into this that there's really not a problem. Maybe that's the issue. And I hope that's the case, but maybe there is a bear around that corner, and I really think it'd be wise for us to just take a minute, stand on that trail, take a deep breath, and come back and look at this with fresh set of eyes. In conclusion, I am reminded again of the federal mandates that's been discussed so many times. We talk about the wolves. That is a little bit different of a situation. We didn't ask for the wolves. We weren't given an option if we wanted to manage the wolves ourselves. We had to go out and get that. That wasn't part of the Endangered Species Act, unlike the EPA where they allow for state management. But we ended up with wolves. They came into the state. We were given federal money to help manage and address that problem with the wolves. Not too long afterwards, we had lots of wolves, and we had no money. I'm afraid that our health exchange system that we're voluntarily accepting here is just a wolf in a surgical smock, and we're going to be left with no money to end. It is with the utmost respect that I suggest to you, members of this body, that maybe you agreed with one little thing that I had to say there. And if you did, then maybe you should vote no with me on that. And I hope you will vote no. Thank you.
Gentleman from District 25.
Mr. Speaker, rise to debate in favor of the bill.
The gentleman has the floor.
I've always been a man of few words, and I don't see any reason to change that now, but I wanted to be on the record for supporting this bill. And I believe that with this bill, Idaho is protecting the individual rights, state sovereignty to the greatest extent possible within the confines of our government, while recognizing the reality of the law that we live within. So I'll just tell you why I support this. It has annual audits, open meetings, participation is voluntary, has annual reporting, the governance is controlled by the state, has oversight, freedom to change the structure if we want to, and it protects competition. And I would just say to you that a vote against this bill is a vote to let the federal exchange come in. And when we talk about legacies, I want my legacy to be that I refuse to surrender my decision-making to the federal government. Thank you.
Is there further debate? For what purpose does the good gentleman from District 33 rise?
May I have the floor on a point of personal privilege?
The gentleman has the floor.
Thank you very much. I'd like to welcome Mr. Doyle Beck and Brian Smith, who are visiting the gallery. These are friends of mine from Idaho Falls. Doyle is the chairman of the Bonneville County Republican Central Committee. Thank you very much.
Good lady from District 4.
Yes, Mr. Speaker, to debate.
Lady has the floor.
In favor, in opposition to House Bill 248. I didn't have to ponder very long on my position on the state exchange and the implementation by Idaho of Obamacare. I've been an employer in Idaho for over 40 years in a very, very regulated, federally regulated industry. So I've dealt with the federal government for all those years, both myself and my employees. I served for a time on the National Auto Dealers Board, and so I've testified at federal hearings on ergonomics during the Clinton era. I've met face-to-face with a dozen lawyers from the IRS to discuss LIFO parts issues. And if you saw the building they were in and the security in that building, in it and around it, you'd know who's afraid of who. But in any case, we all know that health care reform is needed. It's grown needlessly expensive, and that some who want coverage cannot afford it. Now, the debate is about what the principle of that reform ought to be. Under our Constitution, every individual has a right to care for their health, just as they have a right to life. And it is government's chief purpose to secure our rights. Now, this does not imply that government must provide health care any more than the right to eat in order to live requires the government to own farms and raise the crops. Government, rather than seeking to supply the need itself, should look to see if its own interventions are the root of the problem and should make adjustments to unleash competition and choice. If there is any doubt that control of health care services should not have been placed in the federal or state government, we need only look at the history of Medicare and Medicaid, a history in which fraud has proliferated despite all efforts to stop it. We need to unlock existing health care monopolies by letting people purchase health insurance across state lines, just as they do car insurance and other goods and services. This is a simple and obvious way to reduce cost. What are we waiting for? Unless the consumer is able to compare prices and the quality of service, and unless he has incentives to base decisions on that information, there is really not, nor will there be, a free market in House Bill 248. The answer is that the current health care debate is not really about how we can effectively bring down cost. It is a debate less about policy than about ideology. It's a debate over whether we should reform health care in a way compatible with our Constitution and our free society, or whether we should abandon our free market economic model for a full-fledged European-style social welfare state. The true goal of those promoting state government-run health care is crafting entitlement after entitlement and promising benefits that can never be delivered. We'll have a welfare state where most people pay few or no taxes while becoming dependent on government benefits, where tax reduction is impossible because more people have a stake in welfare than in producing wealth, where high unemployment is a way of life and the spirit of risk-taking is smothered by webs of regulation. I see health care reform of the kind promoted by the Obama administration and our state's House Bill 248 as part of a crusade against the American idea. They must be ignorant of the consequences of their proposed programs. National or state exchanges created with their massive subsidies for middle-income earners would represent the greatest expansion of the welfare state in our country in a generation and possibly in history. Now, I would like to clear up a misconception about insurance exchanges. It makes absolutely no difference whether we have 50 state exchanges rather than a federal exchange, as long as the federal government is where the subsidies for consumers will be located. In other words, despite what some seem to believe, both the House and the Senate versions of health care reform set up a system in which if you are eligible and you want a break on your insurance premium, it is the federal government that will provide it, while telling you what kind of insurance you have to buy. In this sense, the idea of state exchanges instead of federal exchange is a distinction without a difference. Idahoans understand that the problems facing our healthcare system today can be addressed without nationalizing 1/6 of the American economy and become a European-style social welfare state. Idaho employers, that's all our employers, have yet to see the fines and the fees they will pay. I cannot subject every Idaho business, both large and small, to these fines and to these fees. Because the very beginning, the day you begin any exchange, state or federal, begins the fines and the fees. Health insurance policies currently provided by Idaho's employers will not qualify under Obamacare. Many full-time employment opportunities will become part-time, and unemployment will rise. It's our duty now as elected representatives of all these employers and all our constituents to read our Constitution and our party platform, as well as their resolutions, and vote no on the takeover of our very system of government. Thank you.
Is there further debate? Good gentleman from District 20.
Thank you, Mr. Speaker. I was just tired of sitting down and needed to stand up and stretch for a minute, so I thought I'd go ahead and debate.
We could think of something else.
I actually wasn't planning on debating. It's rare that I actually stand up on the floor and debate bills. I don't like for my emotion to come out and people to see it, so I try and not do this very often. I've heard a lot of interesting stories, though, today. Horses and cattle and pigs and you name it, we've heard about it. I haven't heard anybody about airplanes yet. So I thought, well, maybe I should stand up and talk about airplanes a little bit. Actually, I'm not going to do that. I'll save the body. I'm going to be really quick here. I was a little taken back and maybe offended by the fact that I was asked, well, one of them was that if I vote no, I'm voting for a federal exchange. I'm definitely not voting for a federal exchange, and I am voting no. Another one that bothered me a little bit was the fact that somebody asked, what have you done for the last 2 months, for the last 2 years? I can tell you for the last 2 years, I have set hundreds of hours in business committee and have fought off over and over and over the implementation of this, what do you call it, PPACA, whatever you want to call it. It has came to the business committee many times. And a group in the business committee has stood and fought over and over and has managed to hold it off. There's been a lot of fluff and a lot of facts. What I am going to rely on today is my constituents. They have clearly told me, vote no. That's what I will be doing. Thank you.
Is there further debate? Good gentleman from District 10.
Thank you, Mr. Speaker, and good ladies and gentlemen of this body. I am a freshman here in this honorable House of Representatives, and I have the utmost respect for this body and its members. And I will share with you today my thoughts regarding House Bill 248. I'm of the opinion that with the option that we have before us, that the absolute worst case scenario regarding this decision I have before me is to let Idaho default to a federal exchange. This will cost the average exchange user in Idaho over double the estimated operating costs than a state exchange. We also cede every bit of control that we have over to an insolvent federal government that I firmly believe does not have the best interest of Idaho citizens in mind. Despite many misconceptions, or at least nothing that I've seen so far, we do not have the third option of simply rejecting either a state or a federal exchange along the way. There are many who think that if we reject a state exchange, then PPACA will simply disappear and collapse under its own weight. I have done my own research in this arena, independent of lobbyists, of business, of the governor's office, and what I see is I see a president that we have in office that has just won his second term, where this is his signature piece of legislation. He spends money like it's free, and despite what the states do, Obama and his administration are not going to let this program fail. That has become very clear to me from the many conversations I've had over the last few months. So that leaves us with doing damage control. I, as a state legislator, cannot repeal PPACA. I would be the first one to do it if I could. But I can vote to exercise damage control to the best of my ability. I feel that we have those damage control protections built in to House Bill 248. While it's not a perfect bill, I feel that it's strong enough to lend my support. The fact that we have no state liability if the exchange fails. There's been a lot of talk in this body today about the independent body corporate and politic method that was used to establish the exchange. I have learned through countless meetings, reading thousands of pages of laws and opinions, news articles over the last few months, that this is probably the best way to go to limit our state's liability and something that we are very unsure about. We will run the exchange for much cheaper than the federal government, which will save some of our more needy citizens money that could otherwise be kept in our Idaho economy and not take food off the table only for that money to be sent to the federal government. The exchange is a voluntary marketplace for health insurance that any insurer that meets the lawful requirements may participate in, either in-state or out-of-state. The exchange also offers protections for Idaho citizens in this bill, such as keeping our citizens' personal information secure. I was at the negotiation table when we put that provision in, and I made it specifically clear I would like to see that in this bill, and I'm very happy we got that accomplished. We have placed provisions in this law that prohibit the rush of the implementation of an exchange in Section 416109, subsection 2, that reads, should the Federal Department of Health and Human Services and or the United States Congress change both the establishment date and the eligibility limitation date for the exchange, the governor shall, upon his determination that such events have occurred, issue a proclamation declaring that Idaho will not be obligated to comply until the new dates are set by HHS or the United States Congress. The governor shall file such proclamation with the Secretary of State. This effectively makes sure that we are not rushing into this ahead of time if the dates are changed. We have placed a provision in this legislation, Section 41-605, subsection 2, Section I, that we've heard referenced many times in this body today. The intent of that piece being put into this bill was specifically for the Oklahoma case and many other pending lawsuits that may come against this legislation. I hope that Oklahoma is successful. More power to them. But in case that they are not, and in case they are, that we would be able to remove this from our state exchange immediately effective with this section. And I've heard a lot of talk in this body today about legislative oversight. That was my problem, my personal problem with the gentleman on the second floor's original version of the bill. So I've worked diligently, as I know that several others have, in trying to establish more legislative oversight, now with 3 voting members on the board, a report to each legislator and the exchange's germane committees each year. Finally, and this hasn't been talked about this much today, finally, if at any time the legislature reviews the reports and feels like the exchange is no longer in Idaho's best interest, the Idaho legislature has the full power and authority to repeal this act at any point in time. I have heard from some that once this is passed, it will be impossible to repeal. I would argue that we as a legislative body should certainly watch this and act responsibly with the passage of this legislation, that we must continue to monitor its interactions with our citizens. The other point is that this exchange is strictly voluntary. In Section 41-1602, the law specifically states that participation in the exchange is voluntary and that no person or employer shall be required for this chapter to purchase a health benefit plan through the exchange. This is not being forced on anyone, and no one is required to use it. There have been concerns raised with this bill that this bill does not protect life or religious freedom. I will tell you that I am a very pro-life person and have been for many, many years. I would submit to you that defaulting to a federal exchange would be the absolute worst option for somebody who's pro-life, considering the very anti-life makeup of this president and his administration and the Department of the Health and Human Services. Idaho tends to be a pro-life state overall, and I am quite confident that we will continue to protect life with a state exchange much better than the liberal federal alternative. Section 41-6108 that reads, pursuant to sections 41-6104 and 41-6105 Idaho Code, the board shall, to the fullest extent practicable, enter into contracts with businesses conducting business in Idaho and employing citizens of this state to staff and provide support for the exchange. What this does is this keeps money in the state of Idaho, supporting Idaho's economy by creating jobs instead of sending that money to the federal government. I felt this important to be included if we were going to do a state exchange. You know, I feel that many times throughout history, we have seen the fallout of public bodies backing away from the negotiating table. If we default to a federal exchange, that is exactly what we do. This is a difficult time in our lives. We are seeing medical costs skyrocket and insurance premiums rise significantly every single year. I don't think anybody in this body disputes that. Reform is imminent, or it will be detrimental to our citizens. There's no doubt about that. Idaho has some of the lowest costs of insurance nationwide. I, however, say that they are still much too high for our citizens and that have some of the lowest wages in the nation. Healthcare indeed needs to be reformed, and I don't believe that PPACA is the answer, nor do I believe that the answer lies in House Bill 248. I have wrestled with this issue for many sleepless nights. Again, I have studied thousands of pages of law, opinions, news articles, and attended countless meetings trying to find an answer to this. I have come to the conclusion that as a member of this distinguished body of the Idaho House of Representatives, I cannot and will not subject the citizens of Idaho to an insolvent federal government that cannot keep its own house in order, let alone Idaho's. I believe that the federal government does not serve the best interests of the people of Idaho. I prefer to stand in front of my people in these turbulent times rather than willingly cede all power and control just to hand them over to the federal government, especially if Idaho has the option of being proactive and doing the job right. My job as an Idaho State Representative is to govern. I can only govern with the facts that I have in front of me. I refuse to govern on unproven opinions. Those facts are that we still have an exchange either way. I prefer to have Idaho citizens that make up the board, Idaho citizens that are the navigators for the insurance plans, and it is imperative to keep the funds associated with the exchange in Idaho's economy and utilize Idaho citizens that we can engage if we have concerns instead of despairingly trying to contact faceless bureaucrats in Washington, D.C., all while fighting to repeal PPACA in its entirety. The fight that we face regarding PPACA is not the exchange portion of the law. It's the entire law itself. That needs to be done at the presidential ballot box in 2016 and at the federal level. I believe that Obama's administration are trying to accomplish eventually is a single-payer system such as Medicaid. If we default to a federal exchange, I am of the opinion that this puts this administration one step closer to accomplishing that. This is a path that I am quite sure that we as a state do not want to explore. I think that we all have the common goal in mind here in protecting the state of Idaho, but just different paths of getting there. There have been many arguments in opposition to this bill today. We don't have a fee cap. We are very aware of the new rules that come from HHS. We don't have legislative control. There are over half the states that have rejected a state exchange. In my mind, Idaho is a true leader among the great United States. Great leaders, to me, stay in the fight. They stay at the negotiation table. I am convinced that Idaho can run circles around anything that the federal government wants to do. Maybe it's my lack of institutional knowledge, but I haven't had anyone explain to me how we can reject Obamacare in its, Patient and Protection Affordable Care Act in its entirety. But if somebody were to show me, I would be the first one to sign a letter to get that done. The first one. I have all the same concerns that those of you who oppose House Bill 248 have, but I feel comfortable that we have taken the necessary precautions with this bill to move forward, to at least give it a try to see if this is the right path for the state of Idaho. For these reasons, I have decided to support House Bill 248 to protect Idaho citizens from harmful federal policy. Thank you.
Is there further debate? Hearing none. Good lady from District 35, for what purpose do you rise?
Mr. Speaker, for the second time briefly.
Does any member wish to debate the bill for the first time briefly? Good lady from District 9.
Thank you, Mr. Speaker. I will try to be very brief.
The lady has the floor. You take as much time as you want.
Thank you, sir. Members of the House, I will not go into all the rhetoric because you've heard everything that there is to hear. There is one thing, though, I would like to clear up, and that is about the Endangered Species Act. ESA is not mandated as a tax on every Idahoan. Idaho was not given the option to manage wolves on our own without any federal intervention. The feds had very strict rules. It was only years later did some of those rules relax, and only with delisting could we operate almost independently, but not quite, because we are still under a 5-year probation period. I believe we have about 3 left to go before we have complete control. So that is not an appropriate thing to mention. What I would like to mention, though, is our Constitution, the Idaho Constitution, Article 2, Section 1, the powers of the government. We have 3 branches of government, and I would like to remind you of that, please. And we take an oath to this. The legislative power of the state is to be vested in the House and in the Senate, not in the second floor. This bill came from the second floor. The second floor allowed or rejected what was put into this. And that is what I would like to get back to, this bill and the words that are in it. And to remind you, we are a separate branch of government, and we are independent of the executive branch. Some of our good members here have tried to get us back on course with looking at this bill in particular. And I would like you to look at page 4, line 4 and 5. This is the powers and the duties. This says that the, let me get a copy of the thing. The board shall perform all duties that are necessary and appropriate to implement the exchange. Now, I have read many hundreds and hundreds of bills coming through this body in the last 20 years, and I have never seen language like that. That is no kind of oversight for a legislature to put into law. 3 voting members of this body and the body across the rotunda is not oversight. 3 votes out of 19 on that board. There is no other body, politic and corporate, with these kind of issues that touch every Idahoan with such a federal mandate and enforced by this state. This bill is clearly not about true state sovereignty. It is not about fulfilling our legislative duty, nor our duty to the Constitution, nor our duty to our constituents. As the gentleman from 28 stated, this is the most important vote we probably will ever make. This bill is not the bill that we should have before us, whether you want a state or a federal exchange. This bill has tremendous problems, constitutional problems, and I would urge you to vote no. Thank you.
Is there further debate? Further debate for the first time.
Mr. Speaker, good members of the body. I've
The gentleman from District 12.
Thank you. I've sat here probably, I don't know, 6 hours anyway, all tensed up, ready to say something. And I want you to know, if I say anything that's out of line, give me some gratitude as my good friend and the gentleman from District 14, because I've been weighing this from the moment I got elected. Well, actually, before I got elected. And I got all these notes, and I wanted to go through all this, and I probably won't go there. I'll just go off the cuff. When I ran on the premise that I'm a banker and a businessman. And I said, I will come over here and fight for jobs, jobs, jobs. Those people who know me, they know that was my tagline on everything. And as I'm debating and I'm going to forums, all of a sudden I hear this thing about exchange. Well, as a banker, to me, all I know about exchanges is foreign currency exchange. So all of a sudden I'm thinking about, well, I know there's a European meltdown. Are we talking foreign exchange? How's that going to affect Idaho? I don't know. So I started checking it out. I asked my constituents, what do you know about the exchange? I don't know. All I know is it's a federal exchange, and if you vote for it, you're not going to get elected. Oh. So that means what? You better vote for a state exchange. You better be on top of that state exchange. Okay, I ran on the premise of a state exchange. Guess what? I got elected overwhelmingly. Why would I change that position today? I get over here, I'm roaming the halls of the Capitol. Well, let me back up, because a significant event happened the evening that I got elected, and you all know this, on November 6th. There was a president that got reelected. And I can tell you in my election fanfare that we had in Nampa, it threw a wet blanket over everything. So I get over the Capitol and roam in the halls, and all of a sudden this tone is changing. We don't want a state exchange. Vote no. Vote no? I thought you said if I had states' rights, I need to vote yes on the state exchange, otherwise I default to a federal exchange. No, just say no. Vote no. Well, you know, if I vote no, then I'm going to end up with this federal exchange. I don't care. It's a constitutional issue now. You vote no. Really? Well, I get appointed to JFAC. And as you know, we've been meeting for 2.5 months in JFAC. Well, what have I been doing in JFAC? I've been appropriating $3 billion for the state of Idaho. Close to $3 billion. Well, guess what? Our nose is already under the tent, and we got tar all over us. We've been under the premise of ACA since 2009. It's not going away. I'm shaking to think that we're going to sit here and not vote for some action that we can control and allow the feds to roll over us again with federal mandates, and we're going, this isn't going to happen. It's not going to come on us. It's not going to be there. Well, I watched a movie when I was younger in 1976, and some of you probably saw it. It was called The Network. And the premise of the movie was the anchor who was a weatherman. The ratings were going down in the network. And they kept telling him, you need to get the ratings up, need to get the ratings up. So this weatherman was doing all kinds of crazy stuff, going back and forth, until finally got to the point he drove himself crazy. So what did he do? He gets on national TV and he yells out, I want you all to go to the window, everybody in New York, and yell out, I'm paraphrasing here, I'm mad as heck. And I don't know what to do. And I'm not going to put up with it anymore. I want to read, Mr. Speaker, may I read from a bill that we just passed a couple days ago?
Without objection.
This is just this is a statement of purposes for 2 sentences. This legislation is to protect Idaho law enforcement officers from being directed through federal orders, laws, rules, or regulations enacted or promulgated on or before January 1st, 2013. I wasn't happy with that bill. I was told by several of you here that that was a preemptive strike. It was to get those bears out of there, because we didn't know what was going to be coming at us from the feds. So I voted for it, and it passed. Let me read you the first few sentences, if I may, of the statement of purpose from Bill 248.
Well, the gentleman can always read from the bill.
Well, thank you, Mr. Speaker and members. It is a public policy of the state of Idaho to actively resist federal actions that would limit or override state sovereignty under the 10th Amendment of the United States Constitution. Through this legislation, the state of Idaho asserts its sovereignty by refusing to surrender decision-making authority over health care issues, which are matters appropriately left to the states and individual citizens. If that isn't a preemptive strike, I don't know what it is, or I don't know what is. Ladies and gentlemen, I'm an Idaho native. I'm mad as heck, and I'm not going to take it anymore. Vote for 248. Thank you.
Is there further debate for the first time? Gentleman from 9.
Mr. Speaker, I'm an Idaho native as well. I'm mad as heck, and I'm not going to take it anymore either. Good. You know, I have been offended somewhat by people saying that if I don't vote for this bill, that I'm voting for a federal exchange. I think we all feel some of that, some offense at that. I could say the same thing, that if you don't vote against this, you're absolving your oath to the Constitution, to uphold the Constitution. I'm not going to say that.
Good. There have been allegations going back and forth, and it is late, and so I'm glad that the gentleman recognizes my predicament.
I do. I understand very well. Well, Mr. Speaker, ladies and gentlemen, I have heard the argument that this is the law of the land, and I just want to say that it is the law of the land, but it is only the law of the land if we allow it to be, if we sit here and take it. And it's said to be the law of the land because of the supremacy clause of the U.S. Constitution. But think about when that Constitution was written. What the framers were afraid of a strong central government, and they enumerated the power delegated to the federal government, and as the 10th Amendment says, the rest were reserved to the people, or to the states, or to the people. And under the United States Constitution, as deliberately designed, the states and the state legislatures have a great responsibility. As James Madison said, the state legislatures will jealously and closely watch the operations of the government and be able to resist with more effect every assumption of power better than any power on earth can do. And the greatest opponents to a federal government admit the state legislatures to be sure guardians of the people's liberty. And another framer of the Constitution, John Dickinson, said, "Each state is, and is to be, sovereign and supreme in all matters that relate to each state only. It is to be subordinate barely in those matters that relate to the whole, and it will be their own fault if they allow if the several states suffer the federal sovereignty to interfere in the things of their own jurisdictions." Well, ladies and gentlemen, this bill was passed by Congress and signed by the President. It was upheld on a 5-4 decision, but I've got a decision from one of the justices of the Idaho Supreme Court that says it's clearly unconstitutional because it was upheld on the power to tax. Well, the power to tax, the Obamacare penalty is not an income tax. It's not a property tax. It's not a tax on any commercial transaction. It's only a tax on a defined group of people, those who fail to purchase government-mandated health insurance and have incomes above a specified amount. As such, it would be a capitation tax. And I would refer you to Article 1, Section 9 of the Constitution to see what that says about whether you think it is constitutional or whether it is not. You know, given the two quotes that I just told you from the two framers of the Constitution, do you think that the founders intended for the federal government to be supreme in all cases? I certainly don't. I think that they were intended to be supreme only in those enumerated cases, only in those enumerated powers. You know, and I think that this bill is one of those issues where we need to push back. We need to not only say no to this House Bill 248, which sets up a state exchange, but also say no to the federal exchange and not help the federal government when they set it up. They can't run it without our help. They cannot do it. We have to participate for them to be able to do it. And I want to relate a little story to you that that Ken Ivory told when he was here about when he was growing up in Utah. And he told the story that he used to go out to his grandparents' farm, and one of the chores he had to do was to gather eggs. And he remembered putting on his heavy coat and thick gloves and going into the combat zone to gather the eggs, because all the chickens were going to try to peck him. And now he has children of his own, and he's moved out in the country, so he went and bought some chickens. And to teach his children some responsibility. Well, when the chickens started laying, he put on his heaviest coat and his long gloves to show the kids how it was done. And they went in to get the eggs, and guess what? The chickens didn't peck. They just let them gather the eggs. So he ran back to the feed store and he said, "There's something wrong with my chickens. They don't peck." And the farm store owner said, "There's nothing wrong with your chickens. We've bred the peck out of them." Well, ladies and gentlemen, I think that's what's happened to us. Over the years, we've had the peck bred out of us. You know, we are not willing to stand up to the federal government. And I think that it behooves us to stand up to them and say no, not only on this, but there are other issues that we're going to have coming forward that we need to stand up to the federal government and say what's right is right. And in closing, I just want to say, read the quote on that sign right in front of me: "There's no right way to do the wrong thing."
Is there further debate for the first time? Good lady from District 11.
Thank you, Mr. Speaker, and thank you, members of the House. I know it's getting late, and I've taken pages out of this and rewritten things, but I think I have another perspective that I'd like to offer to you. Before I begin, though, I'd like to thank everybody in this body, both Republicans and Democrats, for being so civil and so kind today. And this is really how we should debate and how we should be respectful and how we should work for our state. What I'd like to talk about, too, here is about PPACA itself. And I really want to address something that has been hit with me oftentimes, and I constantly hear that, well, but if you vote for this, then you're implementing PPACA. And I really want to make that clear, and I know the body knows that, but I'd like to make that clear to other people that that is not implementing PPACA. Things of PPACA have started to be implemented back in 2010, and I'll give you just a couple examples. 2010, they established a temporary national high-risk pool to provide health coverage to individuals with pre-existing conditions. To provide dependent coverage for adult children up to age 26 for all individual and group policies. Require health care plans to provide a minimum coverage without cost sharing for preventive services, and even to impose a tax of 10% on the amount paid for indoor tanning. People who have been tanning have been paying a tax for 3 years. PPACA has already been here. And for those of us who have health insurance, and especially those of us in the body who have insurance through the state, if you have a health insurance policy, it's a product already of changes because of PPACA. It is here. And we do have to understand that. And some of us think they're good, some of us think they're bad, but that is a separate issue. What I really want people to understand, though, is if you look at the whole situation, PPACA was implemented back there in 2010. And what happened was you had a president who basically had control of the House and the Senate. If the federal government at that time wanted to institute a socialized medicine, wanted to institute a federal exchange where they had complete control of all the issues, they certainly had the willpower to do it, and they owned both houses and could have done it. And what came out of that was that is not what happened. There was actually an option built into PPACA for the states to be involved. And I'm really actually quite dumbfounded that we're fighting over having the option. Why wouldn't we want to have the option? Had the federal government simply stepped in and handled it all and took control over all of it through Congress, we wouldn't even be having this conversation. And we wouldn't even be having the debate. But I'll tell you what, I'm going to stand up here and be glad that we're having the conversation. I'm going to be glad that we're having the debate. And I'm going to choose the option every single time when it's there. Because someday it may not be there. And that's why we are going to vote yes on 248, because we want to preserve our option that someday in the future may not come around again. I also would like to just stand here as a conservative Republican with the rest of my party. I know that my party are conservative. I'm pro-life. I prefer local control, and I've always run on the premise that I'm an independent thinker and I'm not mired in strict ideology. I support the Idaho businessman and the over 500 businesses which have asked for a state-based exchange, and the many constituents who have asked for that as well. We heard that it was talked about how the people that came in and the only ones in support were the lobbyists that stood up for these organizations. And lobbyists did stand up for those organizations. But I want to remind you that those organizations are our businesses here in the state, who employ thousands of people, who pay their taxes, and who are going to be directly involved with PPACA on a number of levels. And I'm kind of glad that the lobbyists stood there instead of the thousands of people that would have had to come through the line. But the point is, those businesses said, we want to work with our state. Do not have us work with the federal government. And really, as a businessman, it has always seemed to me that eventually the businessman ends up being the one that holds the bag. And so for those 500 businesses that said, please let us work with the state, then I think we owe that to them, to listen to them. Communication in my district, really overall, if we counted it all up, for a state exchange has been very, very positive. Businesses and individuals. Absolutely very positive. And so I'm going to stand up for them. And one other thing that I want to talk about is there have been a number of people in the body here who we've had an opportunity to work on this bill for the past 3 years. And it's been delayed, it's been stalled, it's been changed, it's been a whole lot of things. But time is up. There is no more. We have deadlines. Our Health and Welfare Department that is in charge of Medicaid has deadlines they have to meet. And I am going to tell you that they have a responsibility to take care of the citizens in our state here who, unlike us, and those of us sitting in here, they absolutely are dependent on medical care for their very lives. And we can't play this game anymore and put people at risk. It's simply time to go ahead and take the vote. And that's what we need to go ahead and do today. The other thing that I'd like to mention here is that there have been a number of people who have worked on this bill, who have made changes, and I'm very proud that people have come forward to do that. I think that what's important here is that we want to be sure that we are not worried about our elections. We should not be worried about our personal legacies, and we should not be worried about ourselves. We should be worried about the citizens of the state of Idaho, and we need to do the absolute best job at this point in time, under the circumstances that we have now, to protect our citizens and support them the best that we possibly can. And I want to say that Idaho should be a leader. We should not be a follower of the 25 other states who just want to acquiesce to the federal government. I don't think that that's the best way that we should go. We need to embrace our option, and we have an option. And that's what's really important here. And that we need to embrace that, and we need to work through that and make it the best option that we can. This is a starting point. And as we go through the years, we will have other opportunities to keep working on this so that we always take care of the people of our state first. And I think we really need to keep that in mind. So I encourage all of us to simply just go ahead and take the vote. We don't need to debate 2-3 times. I don't know how many times you can kill a horse. I think we've covered probably just about everything. So I encourage us to take the vote. I would surely like to see our House put back together, and so that we can all work as a whole group to take care of our citizens and to help make Idaho as successful as it can under whatever circumstances happen to come our way. And thank you very much, ladies and gentlemen.
Is there further debate? Good lady from District 6.
Thank you, Mr. Speaker. Point of personal privilege.
Lady has the floor.
Thank you. And is it appropriate to refer to a question earlier today?
It kind of, I don't know. Let's see.
Get in more trouble?
Well, a personal privilege is more appropriate to introduce, maybe arrange advise the body of some procedural move coming on. So,
well, Mr. Speaker, I wanted to reference a question that I asked of my good colleague from District 6 earlier, and I had received some misinformation.
Apologies are appropriate.
Okay, thank you, Mr. Speaker. And I wanted to apologize if I had an error in protocol and I meant no disrespect. And collegial relationships and orderly, the way we operate is very important to me, and I wanted to be sure to say to the good gentleman from District 6 and the chairman from 27 that I hope they will accept my apology.
Thank you, good lady. Is there further debate? Good lady from District 35 for the second time.
Thank you, Mr. Speaker. I will be brief. One of the things that I didn't bring out in my debate that I think should be aware of, that people should be aware of, is in the bill on the second page. There are a lot of things that, as outlined, the board shall consist of, and says, subject to the provisions of this section, members of the board shall collectively offer expertise, knowledge, and experience in health benefit administration, health care finance, health plan purchasing, health care delivery system, administration, public health and health policy issues related to, and I guess my question was, where are the consumer rights? Nowhere in the bill, Mr. Speaker, do I see where there are consumer rights mentioned as part of the things that ought to be of major importance in this board. There's nothing in there that talks about consumer lower costs and consumer complaints. Mr. Speaker, I have found some curious things that I would like to just mention in closing. One of the things that we have here today been counseled by lawmakers of some historical knowledge, particularly we also have been counseled by our Farm Bureau, who are part of our constituents, and we seem to have set that to naught. And I found it curious, Mr. Speaker, that our Democrat legislators, friends, have been very quiet and not debated this bill. And so, although our Republican Central Committee met, Mr. Speaker, and passed a resolution against the state exchange, it will be Republican legislators who will pass this tar baby. And I do hope that you will take that into consideration when you vote and vote no.
Is there further debate?
Speaker, I hate to stand up again, but I feel that I need to.
I'm going to recognize the gentleman from District 15 first.
Oh, okay, fine, thank you.
Thank you, Mr. Speaker.
He has his voice back.
Yeah, well, not so good.
Gentleman from District 15 is recognized to debate for the second time.
Thank you, Mr. Speaker. Just four points that came up in the debate. First, there was some discussion about Idaho having the lowest cost, and that's true. But why do we have the lowest cost? It's because we haven't had a lot of mandates. That's going out the window. That cost from all the mandates is going to affect everybody, and the cost of operating the exchange is a minor cost compared to that cost. I think it's speculative to say that we can run it cheaper. As I indicated, Delaware indicated that they thought the federal government could run it cheaper, and then the state exchange would be the most expensive per applicant, per participant. Second, on the effect of the Supreme Court decision, there were three important issues that were decided and nothing else. Number one, our 10th Amendment rights as a state were upheld. They cannot compel us to take on the expansion of Medicaid. Number two, individuals were protected to a certain degree because the court said the law could not be supported based on the Commerce Clause. How was it supported? It was based on the tax law. Didn't say that the other aspects of Obamacare are constitutional or unconstitutional. Those issues were not addressed. The personal mandate was addressed. Medicaid expansion was addressed. That's it. Number 3, there was some discussion about leverage. I find it hard to believe that we have a lot of leverage once we go into the system. But 26 states have a lot more leverage working outside the system. I think the good gentleman from 9 was correct. We don't have to do anything. We don't have to cooperate. They can come and they can set it up. I think we heard about nullification. Well, what is nullification? If we passed a nullification bill like Oklahoma did, what does that do? Nothing. The feds will still set up this exchange, or we'll still set it up. How do we nullify? We say, no, we're not going to cooperate. In fact, we have a law in the books that says that now, our Idaho Freedom Act, which I was a sponsor of. And it says that no agent of the state of Idaho shall assist in enforcing any penalty. Well, let's take an example. Because this exchange is supposed to be voluntary, and you're supposed to be able to buy insurance outside of the exchange. What's the exchange for? It's to funnel subsidies. It's to impose a tax to force people to go through the exchange. But other than that, it's voluntary. So yes, there can be insurance products outside. So let's just assume we have a citizen of the state of Idaho who says, I don't want to buy insurance through the exchange. I don't care if it's a federal exchange, if it's a state-based exchange, I don't like it. It's Obamacare. So I'm going to go find some insurance outside the exchange. Well, what does that do? It imposes a penalty, a tax, from the personal mandate. First year, I think it was $95, and it goes up to $600. But that's a personal choice. They can go outside. Well, what else does it do? It triggers a penalty against the employer. Because if the employee does not have a qualified health care plan, then the employer is saddled with a $2,000 penalty. Does it make a difference whether we have a state-based exchange or a federal exchange? No. It'll happen either way. In fact, we become complicit in imposing that penalty on the employer. I refuse to do that. Thank you.
Further debate? Good lady from District 33.
Thank you, Mr. Speaker. To debate for a second time.
Lady has the floor.
Thank you. We had a comment on the pre-existing services that has already been put in, and it reminded me of something within the blueprint that was submitted. In section 3.14, I apologize, I've lost my page. But it basically states that because of these pre-existing conditions going away, that what it is, our state exchange is then responsible to bring all people onto the exchange. If we create this exchange, we are agreeing to try to bring on all of our citizens to this exchange. I'd like to bring you back to the law itself and remind you that the Supreme Court deemed this constitutional because of a taxing measure. On page 4 of House Bill 248, starting on line 34, states the exchange nor have the authority to impose upon or collect from any person any penalty for failure or refusal to participate in the exchange or to purchase a health benefit plan or a standalone dental plan. Why can they say this? Because, and I have an AG's opinion on this, they emphasize that the state officials and political subdivisions have no enforcement responsibilities with respect to the individual mandate. The Internal Revenue Service, in other words, is exclusively charged with the duty to collect and, if necessary, enforce the individual mandate. Mr. Speaker, may I have permission to quote from another attorney?
They're getting tired, but let's ask them.
Okay, I'll be quick.
Without objection, the lady may read.
This is from the, and I'm going to massacre his name, the Troupas Law Office. He gave an opinion regarding the Idaho Health Freedom Act. The act of collecting and reporting personal information to the IRS may not equate to imposing, collecting, or enforcing the tax penalty of PPACA. However, a very strong argument could be made that it aids and abets the imposition, collection, and enforcement of that tax penalty. Because without the essential data provided by the exchange, the IRS and HHS would be deprived of the means of enforcement. Thus, an equally strong argument could be made that providing this information, the state exchange is acting to effectivate any penalty which is prohibited in our current law. Again, do we willingly and knowingly want to accept the terms of this? Do we willingly and knowingly want to impose this tax upon our citizens? For me, it's very simple. No. I urge your no vote.
Is there further debate? Good lady from District 8.
Well, Mr. Speaker, I'm not sure what kind of debate this is. I've enjoyed the debates. As I've sat here all day, I began to wonder if the two sides were even debating the same bill. And I think we knew when we came in this morning that noses had been counted and heels were dug in, and we seem to be the only body politic in the planet that would kill a horse in order to have a dead horse to beat. So unless you've got something really important to say, let my people go.
Is there further debate? Would the good gentleman from District 27 care to close the debate?
Thank you, Mr. Speaker. And Mr. Speaker, I'm going to be extremely brief. There is nothing that
That's what they all say.
Well, I'll let the body be the judge, Mr. Speaker.
You take as much time as you want.
There is no point that I can make that hasn't been brought up, and there's no point that I can make that it's going to try to change anybody's mind here, nor am I going to try. I just want to say that I'm very proud of all 69 members of the House of Representatives. We carried on a debate today that was extremely passionate, extremely heartfelt, and I think we did the citizens of Idaho proud. I really do. It's been a tough year, and quite frankly, no matter the outcome, I feel like the world has been lifted from my shoulders. So I'm not going to say any more. I think we ought to go home tonight. We ought to be with our families. I think we ought to come here tomorrow morning. And I think we ought to go to work. And let's get our job done so that we can sine die on Good Friday and not any later than Good Friday. And with that, Mr. Speaker, debate is closed, and I respectfully ask for your yes vote on House Bill 248. Thank you.
The debate is closed. The question is, shall House Bill 248 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Representative Ringo. Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 41 aye, 29 nay, 0 absent and excused. House Bill 248 has passed the House. Is there correction to title? Hearing none, House Bill 248 will be transmitted to the Senate. The House will now have under consideration House Bill
Mr. Speaker, I object.
Mr. Speaker, I thought everybody was tired. It'd be a good time to run that calendar because it'll happen fast.
I know what you were thinking. The gentleman from District 14.
Because I'm being forced to, Mr. Speaker, I ask unanimous consent that the remaining bills on the third reading calendar hold their place one legislative day.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the remaining bills on the third reading calendar will hold their place for one legislative day. Without objection, the House will return to the fifth order of business, report of standing committees. The House is at the fifth order.
March 13th, 2013, Mr. Speaker, we, your Committee on State Affairs, report that we have had under consideration House Bill 265 and report it back with amendments attached to be placed on general orders for consideration. Lurcher, Chairman.
House Bill 265 will be placed on general orders. Good gentleman from District 1.
Thank you, Mr. Chairman. Point of personal privilege.
Gentleman has the floor.
Thank you, Mr. Chairman. Quickly, before I make a motion, there's a bill, House Bill 143, on the general orders on the calendar there, and that bill has some problems. It's about invasive species stickers. This is not a hostile request. This is my bill, but it's not going to be able to be fixed this session, so I would ask unanimous consent that we return that bill to Ways and Means.
You all heard the unanimous consent request to remove House Bill 143 from general orders and refer it to Ways and Means. Is there an objection? Hearing none, so ordered. Good lady from District 35.
Thank you, Mr. Speaker. I'd also like to ask unanimous consent that Senate Bill 1006, as amended, that's been on general orders, could go back to the third reading calendar. The sponsors that I'm carrying it for did not want the amendment.
Typically, we would just report that out at the next general orders, but you all heard the unanimous consent request. Is there an objection? Hearing none. Senate Bill 1006 as amended will be placed on the third reading calendar.
Thank you.
Without objection, the House will now advance to the 15th order of business. Announcements. Are there announcements? Gentleman from 24.
Thank you, Mr. Speaker. The previously scheduled Commerce Committee meeting will take place on Tuesday and not this afternoon. Thank you, good members.
I think you speak for all the afternoon chairmen. Are there further announcements? Good gentleman from 13.
Thank you, Mr. Speaker. It's our intention to do general orders tomorrow morning.
Further announcements. Gentleman from 1.
Thank you, Mr. Speaker. Ways and Means Committee will be meeting upon adjournment tomorrow.
Further announcements. The clerk may read.
Following are the Standing Committee meeting announcements. All of the committees have been canceled for this afternoon. For tomorrow morning, House Education Committee will meet tomorrow morning at 9 a.m. East Wing, Room 41. DeMordaunt, Chairman. Health and Welfare Committee will meet tomorrow morning at 9 a.m. East Wing, Room 20. Wood, Chairman. Revenue and Taxation Committee will meet tomorrow morning at 8 a.m. East Wing, Room 42. Collins, Chairman. And State Affairs Committee will meet tomorrow morning at 9 a.m. East Wing, Room 40. Lurcher, Chairman.
The Speaker would take a privilege at this point to commend the body for your perseverance today, your stamina. I have kept track. There's never been more than 4, well, maybe 5 of you off the floor at any one time. I think that you're to be commended for that. It's been a long day, and you have done very well, in my opinion. The House will now advance to the 16th order of business, adjournment. The House is at the 16th order.
Mr. Speaker, The mule that did hold back did live. And with that, Mr. Speaker, I move that the House do now adjourn until the hour of 10:30 a.m., Thursday, March 14, 2013.
Do I hear a second?
It's my turn. Mr. Speaker,
Good job.
I second the motion.
You all heard the motion. All those in favor say aye. Those opposed say nay. The ayes have it, and the motion carries. And the House will stand adjourned until the hour of 10 a.m., 10:30 a.m., Thursday, March 14, 2013.